the wife, despite being summoned, did not subject her to cross-examination. He filed her exemption, he did not subject her to cross-examination. I have got documents indicating the income of the wife, which will have a bearing on the permanent alimony. After the final decree.
What is the pressing urgency?
Pressing urgency is the matter was day for yesterday. Your lordship will short for time on the ground of pendency of this case. Now, close the case. So now this document is not exhibited. I am prejudiced because the alimony part will not be decided.
Let it be Tuesday.
No, I am praying for today, my lord. You deliver the judgment, it will be infructuous, my lord.
Is the matter is fixed on Tuesday for delivery of judgment?
He has not given any date. That is the beauty. I have inquired from the local council from Qatar. He has reserved the judgment without giving any date. Had he given a date, he can deliver it on Tuesday itself, my lord. So that is the difficulty, my lord. I would not have mentioned, my lord. I would not have bothered your lordship. I have been mentioning there for listing, but Honorable Judge could not. If I am correct.
When have you filed this petition, by the way?
This was filed on, my lord, the exact date, your lordship. Pardon me, it is my lord, more than 10-15 days. I have been trying. And your lordship knows the
When was the impugned order?
Impugned order was passed on 4/11/2024, your lordship.
4/11/2024. Today you are saying that it is so urgent.
She did not appear. Had she appeared, it could have been confronted. That is the difficulty.
But I am not sure that whether it can be, any order can be passed.
My fate. I am not because I cannot say what is.
Now partly you know the fate. Partly you know the fate.
I guess I will convince your lordship because it will have a bearing on the permanent alimony. Your lordship will see telltale documents.
After all, suppose alimony order is passed, heaven is not going to fall. You can very well ask for an alteration.
The family would have had a duty to ensure the attendance of a witness who has been examined.
Okay, we'll see what.
That has not been done.
Okay.
Yes. Big pardon to mention, your lordship.
The matter for issuance of direction to the exigent number to record the statement of the complainant. Statement is sent for 150 for investigation.
This is assigned to this bench or some other bench?
This bench, sir.
Just give the memo, we'll see.
For recording,
we'll see the memo.
Big pardon to mention, lordship, this is a criminal appeal matter. Only clause 1 and 2 of section 3 of SC/XT Act are there, and other offences are triable by magistrate. Your lordship, the petitioner is in custody since 22
What do you want?
maybe listed on Tuesday.
You have been convicted.
Yes, your lordship.
It's a fresh appeal.
Yes, your lordship.
Fresh appeal.
Fresh appeal.
This fresh appeal will go somewhere else. Not assigned to us.
Actually, it is assigned to Honorable Justice G. Satpathy, but he is not there, and
Okay. Fresh appeal.
yes, your lordship.
Tuesday.
Pardon to
Obliged,
mention,
most
my
obliged.
lord, the extension of an interim bail. Petitioner mother is suffering for cancer, my lord. Your lordship shall allow
Tuesday.
the surrender date is Tuesday, my lord.
Tuesday morning.
Oblige.
No problem. Tuesday for surrendering means till 12 o'clock night. Don't worry.
Oblige, my lord.
Yes.
Pardon to mention, my lord. It's a fresh bail application, my lord. Filing this memo for withdrawal of the petition, my lord.
But is it assigned to this court?
Honorable Justice Arke Patnaik, sir, my lord.
You want to withdraw?
Withdraw, my lord. Unless the withdraw memo also.
Release it at 2 o'clock.
2 o'clock.
Why urgent? So urgent?
Because, my lord, charge sheet was filed meanwhile, the charge sheet was filed, my lord. So I filed this application prior to the charge sheet, my
So
lord.
you can wait till Tuesday. What's the great deal about it? Tuesday.
Tuesday, my lord.
Tuesday, yes.
Grateful, my lord.
Beg your pardon, my lord. Item number 80.
I'll
My
call
My humble
Please
request
raise
for
it.
early hearing.
Okay.
For early hearing. Item number 80.
It's listed today.
Yes.
I'll call phase wise. Wait.
I may be pardoned to mention, your lordship.
Yes.
Your lordship, filing this written note of submission for criminal MITS case 24 of 2005, your lordship. Your lordship,
Put it in
there is
file.
another matter. Your lordship, there is another matter for restoration of second appeal, your lordship. There is already a delay of 1 year, your lordship, after the dismissal. May it be fixed next week, your lordship? Any convenient?
Delay. What happened?
Restoration of second appeal, your lordship.
Dismissal.
Dismissal 2024.
Now you are coming 25.
May it be listed next week, your lordship.
Please.
Beg your pardon, my
Yes.
I filed one IA for amendment of the Since the name of the opposite party is wrongly typed in
Typo error. Tuesday.
Pardon to mention, Your Lordship, criminal appeal number 182 of 2025. Mentioned earlier, Your Lordship, was directed to list it today, but it is not in the list. May I pray Your Lordship kindly fix it on 21st?
So why, did I allowed?
Yes, sir, memo was allowed, Your Lordship.
So
last.
why it is not listed? Oh, because of the pressure of further court.
21st, Your Lordship.
Listed and following it also.
My lords.
Yes.
Pardon to
Good.
mention, my lord, CMP 56 of 16. Petition for amendment was rejected. At that time, trial had commenced. Now, in the meanwhile, the petitioner is suffering from cancer. She might die, or there is a stay since 2017.
This is a criminal miscellaneous.
Civil miscellaneous, CMP,
CMP. When have you filed?
2016.
16.
16.
Huh? Next week.
Pardon to make a mention, madam. Criminal revision.
Why have you not got it listed for such a long time? 2016 it is pending.
No, my lord.
Nothing now.
Stay was there actually. Now,
Anyway,
last-
we'll see. Old matter, any
Old
case, it
matter.
has to be out.
Pardon to make a mention, madam. Criminal revision, the assignment of court number 3, madam. Here we have challenged the order framing charges against the petitioner. There's no interim order in force, madam. They are progressing with the trial. The matter will become infructuous, madam.
Next week.
Pardon to mention, my lord. Pardon to mention, my lord. My lord, the case details, online case details shows that,
The other court, yeah.
my lord, online case details shows that the matter has been listed today, but it is not in the list. So it may kindly be taken
You are
up.
complaining against the court or against the
No,
computer?
no, no.
See, let's take it up. Yes.
Pardon to mention, my lord.
Can be taken up on 16th.
Let us see how can we adjust it.
It's a if your matter typographical error modification of order.
Okay.
Wrong.
Take it. Tuesday, Wednesday. Type 1. Tuesday, Wednesday.
It's a CMD matter, my lord. It's the assignment of Honorable Justice Patnaik, my lord. And the urgency is the trial is supposed to be, the trial is coming up on 17th, my lord. And Monday, Tuesday or Wednesday may actually be
16th.
taken up,
16.
my lord.
Let me make a mention, my lord. It's a matter related to Consumer Protection Act. It's a matter of assignment of Justice R.K. Patnaik, my lord. In the meantime, the execution proceeding has been started and the personal appearance has been ordered for the petitioner. It has been posted Tuesday.
What happened to the principal order?
Principal order, they have allowed the complaint petition.
That's
Without
right. Have you
jurisdiction.
challenged that order?
I have challenged that order.
What happened to that matter?
The writ petition is pending. It has not been listed. Right, today, my lord.
Next week.
The personal appearance is on Tuesday, my lord.
Next week, Tuesday. What will happen if you go? Is it a respect issue or ego issue? Go and appeal. You say that I have filed the appeal against that order. What is the great deal about it? What is the great deal? Go and tell the court that I have already challenged the main order. Please hold on. This much. That's all. What's the great deal?
Tuesday, my lord. Listed on Tuesday, my lord.
Tuesday. Yes.
Listed Tuesday. Tuesday.
Yes. Yes. Please. VC mentioning?
Please, my lord. I appear for. I want to mention an IA for 87 of 2025. My local associate is there with the memo. This is actually an IA taken out seeking permission to sell a portion of the property. This is actually arising from a partition suit which is decreed in my favor.
Who is your local lawyer here?
Anupam Das.
Nobody is here.
Oh, I'm sorry, my lordship. There was a coordination mistake. I'm sorry. I apologize.
Yes. We need a memo for that.
Yes, yes. I apologize.
Yes, Mr. Mahapatra.
My lords, page mentioning, my lords.
Page mentioning. Okay.
Any mention item 1 to 5?
Item 4. I have some difficulty today. Can we have it after 3 weeks? I need some instructions also.
And
Great.
request.
An interim order to continue.
Interim.
Great.
Request of principal. Okay.
Item 6 to 10.
Item 11 to 23. 24 to 36. 37 to 41. 42 and 43. 44 to 50. 51 to 56.
I may be pardoned to mention, my lords. I am not physically present, my lord. Item 53. My lords, in view of the ongoing mediation, my lords, the matter may be adjourned, my lords.
Okay, mediation process is still going on. In the matter of 50 weeks, yes.
My lords, I'm grateful, my lords.
57 to 61.
Item 58 matter or present police time.
58 on request. 26. Okay. Mediation process is still. Yes.
Item 39 can be taken. Item 39.
Yeah, what do you want?
May be taken up.
It will be taken up, obviously. If you want an adjournment, you tell me. Yes. 62 to 70.
Your lords, 62 and 63 I seek 1 week time, and I have informed my senior, Mr. Tushar Mishra.
61 and 62.
62 and 63.
62 and 63. You
Yes, Lord.
want an adjournment?
Interim order to
You are
continue.
appearing.
I'm with him.
Okay. Interim order.
Interim order to continue.
Interim order is there, so therefore short adjournment.
That's short date.
Okay. Yes.
Your lordship.
62 and 63.
Yes. 71 to 76.
Your lordship said my friend should mention, I said you mention.
But you have
They are
violated,
just to support it.
violated the standard.
They will grow. Your lordship will see, they will
You
grow.
allow them to mention and
the only
all.
thing I tell them in office.
Actually, the seniors should not mention.
Yesterday there was a second appeal. I asked him to investigate. Today we have come prepared because of him. They are doing. They will do.
Mention, seniors mentioning means encouraging the
Recently,
right of juniors.
Mr. Kapil Sibal and Mr.
Everybody is advised, no, none of the
3 days
seniors
back
are
they mentioned before
agree,
the
that's the problem.
Honorable Chief Justice of India. Your lordship has seen
Every
that.
time the judge, seniors are being asked not to mention, still they are mentioning what to do. Here also the same thing. Yes.
Item 71.
70?
71. 71, I have objection.
Okay. Yes, yes. Will objection. Yes. 77 to 84.
Item 77 may kindly be adjourned.
77?
Adjournment.
77. You are for? Petitioner.
Petitioner on behalf of Vijay Das.
On behalf of?
Vijay Kumar Das.
Okay. On behalf of Vijay Kumar Das. Yes.
Please, your lordship. May I please, your lordship, item number 78. I pray for an 1 week adjournment.
7?
78.
78. Okay. Request. Yes.
Interim order is.
Interim order is there. Short adjournment.
Item 80. I am opposite party number 2, seeking 2 weeks time to file counter affidavit.
So entered a
Petitioner is
for
present.
opposite party number 2 and seeks to seek 2 weeks to file response to the petition. Please the matter to interim order to continue. Yes. 85 to 88. Yes. Yes. 85 to 88. 89 and 90.
Your lordship, beg your pardon, it's a CMP fresh admission matter, your lordship, assignment of Justice R.K. Patnaik. The urgency is that the legal errors of the plaintiff have been transposed and the evidence is proceeding.
Next. Okay.
Next week.
Yes. Item 1. Item 1.
One.
Unless this item
Why
was
you
listed.
people are not coming in the right time for mentioning? Yes.
Unless the item was listed before Justice R.K. Patnaik. Unless we have challenged the Oriate order.
What do you want?
Unless urgent listing, Malus. The matter is listed
Next-
today
next-
before Oriate, Malus.
Next week. Yes. Yes.
Lordship.
Yes.
Lordship, this is for release of the account. The
Release
matter
of?
was release of the account of the petitioner, who is accused of an offense under section 13(1)(e) of the Prevention of Corruption Act, possession of
See,
disproportionate.
yesterday I passed a judgment outlining the guidelines in this kind of situation. Can you just go through that judgment and
I will go through that judgment.
it may be beneficial.
Lordship, then Lordship may kindly call it to Monday or some other.
Next week. Also.
Next week.
Please see that judgment.
Okay.
I've outlined some
Yes,
guideline
yes,
kind of
yes,
thing.
yes, Lord.
That
I
may
will go
help.
through that.
Yes. Yes.
1 and 2.
1 and 2, both. Yes.
3.
Are you saying something?
May I please, Your Lordship?
Sorry?
Okay,
It will be uploaded today. Just
May I please, Your Lordship? Lordship, not to withdraw the
withdraw 3.
item number 3.
3. Okay, withdraw. Yes.
Obliged.
5.
May I please, Your Lordship? My lord, I am challenging the cognizance order passed by the Crown Judge, my lord, on 3/5/2017. The offense under section 452, 294, 506, 323, and 354, 385 by 34 IPC, my lord.
Yes. Yes, yes.
In this case, my lord, the petitioner's daughter had filed a 498A case against the informants, my lord. So in this regard, he has filed many of them cases against the petitioners and petitioners' family, my lord. So in this regard, my lord, I have challenging the cognizance order.
Where is the charge sheet?
Charge sheet, my lord.
Show me the charge sheet.
Yes, my lord. I have filed the charge sheet, my lord. Charge sheet filed on 31/3/2017, my
Well, show
lord.
me that. Which page?
My lord, further I have filed the charge sheet, my lord.
Yes. Oh, okay. Yes. Yes.
Yes.
What are the allegations? Let us.
Allegation against this petitioner, my lord, 452, 294, 506, 323.
All of them are in-laws of opposite party number 2.
My lord. And relatives, other relatives.
Relative. Okay. Let us see. Let us see. What are the allegations against?
My lord, in this regard, I have filed a IA. The petitioner's daughter also filed a RPF before this court, my lord, and which is pending, my lord. So also matter also disposed by this honorable court and dismissed this matter filed by the petition informer's son, my lord.
What happened to 498A?
498A is now, my lord, 498A also pending, my lord.
You filed any petition for quashing?
My lord, I have filed, I am the petitioner.
Issue notice, any notice.
My lord, I have filed the IA for stay, my lord, for the posting.
I don't know what is the stage and you are not able to tell anything.
Yes, my lord, petitioner's daughter has filed a 498 case against the informant's son.
Which petitioner?
Petitioner number 1, my lord.
Petitioner number 1.
My lord.
He has filed a 498 case. Against?
Against the informant's sons.
Informant son?
My lord.
Okay.
In this regard, he has filed this case, my lord. In this
you
case.
say that is a counter case?
Yes, my lord.
It's counter case you are saying. That's what I'm asking. What happened to that case which you have filed?
498 case is also pending.
Pending.
My lord. Mata case also disposed, my lord. Mata case is filed by this informant son, so also dismissed, my lord. Before this honorable court, my lord.
Okay, anyway, these are matrimonial issue notice. Let him move after this. Yes.
My lord, I had filed, my lord.
Yes, I passed it. Yes.
Yes. Obliged.
6.
May I please, my lord, on behalf of Mr. Das, my lord.
Yes.
I may be permitted, my lord.
Yes, yes.
Here, in this case, my lord, this case arises out of a 140 proceeding which was converted to 145 proceeding. My lord, and attachment order has been issued, my lord. I am challenging Annexure 7, my lord, appointing receiver and the revisional order where the revisional court has dismissed my revision and
against this order of
yes, my lord, under Annexure 9.
28/10/2022 order.
Yes, my lord.
Very
My
well.
lord,
Let us see what are the effective order.
before that, I will just, my lord, bring the facts, a little facts of the case, my lord, before your lordship, my lord, so that it will be easier for your lordship to.
Tell me.
My lord, here what has happened? My lord, the scheduled properties, those originally belong to a DT, my lord. The DT, in connivance with the opposite party number 2, my lord, filed an application under section 19. And the permission was granted. My lord, fixing the setup offset price, minimum price, my lord, and directing for auction if my lord, it was also directed that the opposite party number 2 and 2 other to tenants, my lord, they, if they want to purchase, they cannot purchase in the my lord, bid price, my lord, minimum bid price, my lord.
Who are you?
My lord, I am the person who is actually in possession over the property, my lord. Physically, I am possessing the property. My lord, I was a bhagchasi under the, my lord, DT. And this is a lady of...
The 19 order was appealed?
My lord?
19 order was appealed or attained finality?
My lord, two writ applications are pending before the Honorable Court and one appeal is pending before the appellate court. That is under challenge, my lord. My lord, the challenge
that has not attained finality then.
My lord?
That has not attained finality.
Attended the finality. Now, my lord, what has happened? In the year 2021, a 144 proceeding was initiated by the opposite party number 2, my lord. And the learned magistrate, upon receiving the application, my lord, called for a report from the police as well as from the Tahsildar.
See, the court has asked for appointment. See, the fact remains.
No, appointment cannot be made this way, my lord. My humble submission.
Are the opposite party?
No.
Both of you are not entitled.
No, my lord. That is not the question, my lord. That is why I will take your lordship's kind attention to page 50.
50?
50.
Yes.
The Tahsildar has clearly reported in the earlier proceeding, my lord, that is in the year 21, my lord.
Yes.
That I am in possession, I am cultivating the land, my lord. If your lordship will kindly turn to go to the last paragraph, it is submitted that I, along with Circle Amin, Sri Swan, visited the case suit land and inquired in the field with reference to ROR and plan of Mauja, so and so, from which it is disclosed that the paddy has been sown in the case suit land in course of our field inquiry of the case land. The second party member, Sri Pilla Karunakara, Srimati Potturu Surama, the present petitioner, my lord. Party members stated that they were jointly under cultivating possession of the said case suit land since long back. So, my lord, basing on this report, the 140 was dropped. Basing on this report, the earlier 140
issue notice to you are appealing.
I have appeared for
Yes.
the opposite part number 2.
There is a report now. There is a report. Report says that they are in
the
position.
report of the earlier case, what he is saying. That is not possible. You will kindly see the impugned order.
Yes.
At page 71.
Yes.
Paragraph 7.
Yes,
Coming
71.
to see as to whether there is legality or impropriety in the impugned order passed on 28 and 22 regarding attachment of the case land and appointment of revenue inspector as receiver. The order shows that land SDM passed the order after receipt of the report of the IIC Parla Committee and after receiving report from the Tahsildar Parla Committee. The report of the Tahsildar dated 22/10/22 available in the case record shows that the case land stands recorded in the name of the present respondent number 2, whereas the paddy seeds are sown on the same portion of the case land by the present revision petitioner, who is the second party in the proceeding. Accordingly, it is found that...
And all these things needs to be gone into.
But what the present position is, what is the illegality that I am trying to find out from the revisional order? And I searched out, couldn't get the point. My learned friend may get it and your lords may get it. Not even a single point is there. They have filed a suit subsequently.
The only point is neither you are entitled nor he.
No, receiver is
both of you are trying to,
No, receiver is appointed. Sale is in the year 2012. Mind it, my lord. 2012 challenge in 2022.
So let us see what is the outcome of 19 proceeding.
What will happen? Well, the 19 proceeding has filed a writ petition that's pending. Nothing has happened there.
What happened?
My respected son has already appealed
19 is upset. What will happen?
Then sale will be illegal.
So
The question is
changing hand at this stage may
not changing hand.
problem.
No,
There
what's
are
going to
many
be
things, my lord.
What is going to be changed now? Since 2012, I purchased it with permission of the Commissioner of Endowments, and that I am in possession since 2012, and in 2025 he is coming and saying
Page 50 is which date? Page 50
that
which year?
21. 21.
That is in the year 21, the Tahsildar reported, my lord.
21 is another proceeding,
140,
not in this 144.
the 140, yes, 144
Not in
proceeding,
this
my lord.
proceeding, I am saying.
Yes, there was another proceeding, 144 proceeding. The same person had filed another proceeding.
Of late after
That was dropped on the basis of this report.
There is a cloud now.
Yes.
Who is in possession?
I have issue matter there. Ultimately, he has filed a suit.
I'll issue
He
notice.
he has filed a suit.
And
Like, it will be
maintain
said-
status quo. If you are in
Yes, yes, my lord.
No, receiver is appointed already. Receiver is in possession. So
has he
status-
taken position?
Yes, yes.
Show me
My
record.
lord,
Yes, he has taken possession.
even if
No, if
even
he has
if
taken
it
position,
is,
if the status quo, let him continue.
yes,
Let him continue.
status quo.
Let him continue.
Issue notice. Also accept notice. Sir, your briefing council name, please give, sir. Your briefing council name, please.
Right.
So accept notice. In IA, because the parties directed to maintain parties name status quo or to be maintained in regard to the which property?
With regard to property given at page 29, if your lordship will
29.
kindly.
In regard to page 29. Yes. Give the particulars.
Yes, my lord.
Status quo, this one.
Page
Khata number
29,
78,
land schedule jota diya hai.
Khata number 78 of
260.
260, plot number 257 in Parla
Committee.
Khaspa,
Parla Khaspa.
Parla Khaspa.
Area covering 1.778.
Area covering 1.778. 1.7. This 1.78 is a dangerous number. Because this was a dispute there in Ramjanmuni. 1.77 acres. I was contacted.
Probably-
This number is always.
My friend's client has chosen that because the entire purchase was for 5 acres. He has chosen only
This is also
1.77.
The entire
This is also-
property is under challenge in the appeal, where my respected senior has already appeared in the appeal.
Let us maintain
your
status quo.
adjudication.
Yes, yes,
If the
let-
receiver has taken
let-
it, let him.
Let's
Because there are many things.
Your lordship may say that the receiver has been appointed in possession and
No, ସେଇଟା ନାଇଁ ସେଇଟା ଲେଖନ୍ତୁନି ହଜୁର ମୋର
I will record
Yes.
submission only.
right.
whatever is the position that will be maintained.
Mr. Mishra has taken me to the annexure, which one? 50, page 50? Annexure?
Page 50, that is annexure. Page 50 is at annexure 6, Melo.
Annexure 6 to submit that on 19/8/2021, Revenue Inspector of Paralakhindi has given a report ascertaining and stating inter alia that the petitioners are in position. Mr. Senior Counsel Deputy for the petitioner has stated that no prejudice, stated that pursuant to the impugn order, the receiver has already taken over the position of the property subject. I am not delving upon the issue at this stage. However, suffice it to say that the status quo shall be maintained regarding the position over the property number sold.
ସେଇଟା ଯଦି ହଜୁର ରେକର୍ଡ କଲେ ତାହେଲେ ମୋର submission ଟା because there was a interim order by this honorable court in the earlier CRMC and in the revision, madam.
I have recorded your
Yes.
submission.
Revision maybe interim
I'm not
order
delving up.
interim order.
I said I am not delving up in the merits of the case at all. Yes.
ମୁଁ ଯୋଉ କହୁଛି ଯେ ଏପର୍ଯ୍ୟନ୍ତ handover ହେଇନି
Whatever it is there, it is there.
difficulty ହବ କି କଣ ସେ ପୁଣି ଯାଇକି ସେଠି
Yes. Item 7.
Yes, sir. And they wanted to compromise. The matter was referred to mediation. Mediation has succeeded. Mediation
good.
report, yes.
Very good. In terms of mediation report, shall I dispose it?
My lord.
Okay.
All the charge sheet and accused were present before the mediator and.
It's all right. Very good.
Only
Very-
one, may I pray, my lord, one, there is a mistake in the name of, father's name of, pin number 4 in 2699.
In your petition.
My lord, I am submitting Aadhaar card, his Aadhaar card.
Acha, Pujari submits that
Pin number 4 in 2699.
and Pujari submits that the name of the
Petition, opposite party
number 2. There is
four.
a typographical error in the name of the
Father's name, regarding
father's name of the opposite party number
and
2.
age is not
In
there.
fact, the father name is, what is that?
Kalandi Das.
Huh?
Kalandi Das.
Instead of.
Kalandi Das.
My lord.
Kalandi Kumar Das.
My lord.
Inadvertently, Sol Kumar Das has been attacked. Huh?
Age may be also mentioned. Age.
Age is not written. Age 52.
My lord, I have given the Aadhaar card.
What is age?
65.
65. Age.
My
Age
lord.
and name.
My lord.
Correct. And he
Age and father's
placed,
name.
he has placed on record the Aadhaar card of opposite party number
My lord.
4. Okay.
That could be instead of
the matter
Narayana
was-
Das, Kalandi Das should be there.
Yes, yes. The matter was by order dated 4/3/2025. This court has referred the matter to the Odisha High Court Mediation Center for exploring the possibility of a settlement between the parties. The parties have undergone the mediation process. The mediation came out to be successful. The High Court Mediation Center has placed on record the mediation report dated 18/3/2025, which reads as under. Mediation report declared, which reads as under. The counsel appearing for the parties submits that the present matter can be disposed of in terms of the settlement, in terms of the mediation report. Regarding the mediation report is produced above shall form part of the present order. Parties are undertaking to comply with the terms of they are part of the obligation flowing from the mediation report in view of the settlement arrived by the parties through mediation process. Mediation process which was mediation process conducted by the High Court Mediation Center at the instance of the order of this court. The present petition is allowed, and so and so is quashed. What is to be quashed? All PS case number 217 of 2020, corresponding to GR case number 443 of 2020, pending in the court of JMFC, all district Kendrapada and consequential postings arising therefrom are quashed. Yes.
Both the cases.
Both the cases.
One is 217, another is 218.
Yes.
Lord's sake.
Item 8.
Please, your lordship. Sir, annexure 1 is the matter of the challenge matter.
Annexure 1.
Yes, my lord.
Yes.
That is passed by the learned court below on dated 24/10/2024, my lord. Where, my lord, without examining the witnesses, without taking cognizance, without examining the witness, that's the case on section 138 of the NI Act, my lord. And you also will kindly say that without taking cognizance, without examining the witnesses, directly going to pass judgments, my lord. The background is, my lord.
Let us see.
My lord.
Let us see the order.
The background is, my lord. Earlier one 1cc case was filed, my lord. Earlier in that case, my lord, after conclusion of trial, my lord, the case ended in conviction, my lord. Thereafter, the accused in that case and petitioner before your lordship, he challenged the judgment, my lord, before the appellate authority and acquitted in the appeal, my lord.
Cognizance is not taken.
No, cognizance has not been taken. That is the whole problem,
My lord, kindly have a glance to.
Answer, cognizance is taken or not?
Cognizance taken?
In earlier case.
This case.
In this case, cognizance
has been taken.
Yes, my lord, cognizance taken. Because appellate forum acquitted the accused person. Thereafter, I approached the in a leave petition, and in the leave petition, Hon'Ble High Court allowed the leave petition and referred to the land court below, and it is specifically has directed to file one petition under section 142(1)(b) for continuation of delay, and to file one fresh petition under section 138 in Act, and both the petition were allowed.
Where is that order? Where is that order? Show me. Where is that order? High Court order. This is Annexure 2.
Yes, ma'am.
CRLLP number 29. This is the order of the Hon'Ble High Court.
Well, Lordship, come to page 23. Lordship, kindly come to page 23, my lord. That order of the Honorable Court, my lord, in that CRLP,
I'm
that
there.
is quoted, my lord.
I'm ready.
That is quoted, my
1
lord.
minute. Let me
Yes.
read it.
The Honorable Court has dealt with limited prayer, my lord. That is.
Let me read it.
Yes, yes, yes. Yes, my lord.
Yes.
My lord, only the.
Second time when the complaint was filed.
Yes, ma'am.
According to you, delay is condoned, but cognizance is not taken. That's
Not
what-
taken, my lord. Cognizance is not taken. Witnesses were examined and even reasonable opportunity has not been given.
Yes. Yes, sir.
May.
See, the original complaint is not a continuation of original complaint.
My
This was set aside and liberty was granted to you to file a
fresh complaint
along with a condonation of
condonation delay.
and condonation of delay is allowed. And in the fresh complaint, cognizance has to be taken. Otherwise, how will you proceed?
Already admitted.
Where is that?
My lord.
Show me.
Previous proceedings.
I am talking about this fresh one. Issue notice. Don't accept notice. Don't accept notice. Lease the matter on 22nd, 23rd. 23rd. Come with that.
Yes, sir.
Otherwise, I'll have to quash it.
Yes, my lord.
Again, the court has to take cognizance. Otherwise, how can
My lord, last occasion, your lordship has directed to pay the 20% of the check amount, but that has not been.
Bring all these things, sir, on record.
My lord.
Whatever file document he has filed from there, it seems that cognizance is not. Okay, next.
Item 9, your lordship, mediation process is already going on, and the next mediation date is fixed to 23rd of April.
Mediation is still going on. Leave the matter up to 2 weeks. Yes. Yes.
Item 10.
Yes.
My lord, allegations, my lord, both the petition and the informant, victim girl, both are the same village and only distance between 500 meters. They are from both the residents, my lord. FIR is lodged on page 17. First line at the move. Page 17, my lord.
17 years.
Page 17, my lord. Has lodged the FIR.
Want quashing of this?
Yes, my lord.
On the what ground?
Ground that because
Because they are very near. They are
Yes.
staying nearby.
Your
That's the
lordship
ground.
has distinguished rendered the list.
That's the only ground.
Well, because they have
They
compromised.
never do whatever.
No, my lord. What I beg to submit subject to my lord's permission. Even your lordship see the entire medical report and the allegations, whatever may there. No case has been made out either under
You argue on that point. Not
Yes.
that they are
Yes,
neighbors,
ma'am.
so therefore
No,
I
no,
can do
ma'am.
whatever.
Yes, because your lordship can see, my lord. Own
Let us
admission.
see what are the allegations first of all.
Yes, my lord.
What is this says? Charge sheet is filed?
Charge sheet file, my lord.
Okay. Let us
Charge
see
sheet
the
file,
charge.
my lord. Charge sheet file with under 366 and 376 UN.
Yes.
The lordship allegation can see, my lord.
26.
My lord. 376 UN. But lordship, what is his own allegation, my lord? Anita Malavi Swanso, Amo,
What are you
Border,
reading?
but page 17, my lord.
No, come to the charge sheet now.
Charge sheet, my lord. Yes, my lord.
17, the FIR was in some other provision. Now
My lord.
they filed
Not the,
676.
my lord, the English version is a page 32. The charge sheet
You
final for
Come to the page 32, yes.
page 32. On 23rd 5/2019 at 6:30 p.m., complainant Anita Malavi, daughter of Swanso village, Bodaponasai Soda, PS Soda district appeared and presented a written report alleging therein to the effect that one Mahendra Behera, son of Swanso, and gave
Who are
false-
you? You are Mahendra Behera.
I am the Mahendra Behera. my
Yes.
Gave false assurance to marry her and also give status of his wife had liked with the complainant on false assurance and so on. So on 14/5/2019.
The only you persuade her and bring her. That's the only way. Otherwise, nothing can be done. Nothing can be done.
My submission is, my lord.
164.
164, lordship can see the first medical report, my lord. Medical examination, page 43 and 40.
Today I can't do all these things. 164 is there. There is
Same, my lord. The
allegation of rape is there. Then
no, your lordship.
I see in the I will appreciate everything at this stage and record an acquittal.
No, what my submission, my lord?
164.
My lord, 160. I have yes, my lord. But before that, my lord, these are the allegations. What he has stated.
You can persuade your neighbor with whom you have done it with as if it is your right. Go and persuade and bring us. That's the only option where you can be saved.
No, my lord, that is not the subject of my lord's rectification. My lord, what I may be wrong. What happened, my lord? Now, my lord, this what is the situation there? She herself admitted that the persons of his brother and nephew has brought her to the present petition of the. There is no question of kidnapping, my lord. Regarding page 46, your lordship can see for a moment.
I'll issue notice. I'll simply.
No, sir, appear करते
हैं
Is
there any chance of settlement?
Actually,
The fact is, see, you are in relationship. And see, the one line I'll read it. That is the reason I persuaded to issue notice. ମହେନ୍ଦ୍ର ରାତି 3:30 ପାହାନ୍ତିଆରେ ଆସି ଆମ ଘର ବାଡ଼ିରେ ମତେ ଦେଖା କରୁଛି. But you have to place it on record, sir. Pardon? You have to place it on record. Otherwise, where will I keep?
Where bill, my lord?
You have to file it. File it, I'll take it up next. File it.
In the court, yeah, the counter.
Because the big volume.
Well,
Give a copy. Give a copy.
I have already given the copy. My
You
lord.
got the copy?
One thing I bring to your lordship.
Today?
No, last date I have.
Okay,
given.
file it.
My lord, one thing I bring to your lordship, my lord.
Mr. Mohanty.
My lord, your lordship kindly. Similar, my lord, another co-accused has challenged it. The additional commissioner of commercial tax, I have the commercial officer, my lord.
Yes.
Same thing I have challenged. This honor court, I will not suppress, my lord. This honor court
has passed this order, my lord. If your lordship will do it, my lord, then both the matter can be heard together, my lord. Same, co-accused in same with this case. Also, who has the additional commissioner commercial?
So issue notice and application will be right. Issue notice tag with this matter. And in the meantime, petitioner is at liberty to move application before the High Court seeking.
Then you I will find it. Then you
submits that he would be placing on record the additional document to substantiate it. Let him do so within a minute. Yes. Please the matter along with this. Yes.
Both the matters can be disposed of together.
I think
here only point that they have not taken any provision of the VAT Act and other some procedure to, my lord, issue penalty.
We'll see what can be done. Yes. Because the coordinate bench has issued a notice and passed that order.
That's it. The fact had not been, my lord, when FIR was lodged, at that time the penalty has already been calculated and everything had been done.
We'll see, we'll examine that. We'll examine. Yes.
Lordship, item 12 is fixed for at 12 p.m. 12 p.m. Kindly, Lordship. 2 p.m.
Sorry, I couldn't follow you.
12 p.m.
Okay.
30.
Last occasion, as to satisfy regarding the limitation, commencement of the limitation period. Here, my lord, the offence is committed under section 194(1)(a) of the Motor Vehicle Act. The limitation period is 6 months, my lords. Here, the PR submitted after 1.5 years. And however, the cognizance is taken, we have challenged that order. And so far, the limitation periods, my lords, that is 468 prescribes the limitation period. And this meant that is 469 CRPs, my lords. Commencement of period of limitation 469(1), the period of limitation in relation to an offender shall commence A, on the date of the offence. There are 3 contingencies are there. A is on the date of the offence, or B, where the commission of the offence was not known to the person aggrieved by the offencer. Offence, or to any police officer the first day on which the such offence comes to the knowledge of such person, or to any police officer, whichever is earlier. Or C, where it is not known by whom the offence was committed, the first day on which the identity of the offender is known to the person aggrieved by the offence, or to the police officer making investigation into the offence, whichever is earlier. So out of these matters, contingency A is applicable here, matters on the date of the offence. So here prosecution, here PR submitted, matters offence committed, that is page 12. That is prosecution. Offence committed on 11/5/2023, matters. Page 12, matters.
12.
Yes, matters.
Yes.
This is PR submitted by the ARTO Khurda. The challan date mail is there in the first column. That is 11/5/2023. So offence committed on 11/5/2023. It is submitted, your lordship, on the top of the letter dispatch date.
Yes.
That is
8/11.
8/11/2024. It is more than 1.5 years, my lords. And cognizance is taken without going to the limitation period.
When the cognizance is taken?
Page 9. Order dated 18/11/2024.
18/11?
2024. Here under section 194 of the MV Act is received.
Motor Vehicle Act doesn't provide any.
No, limitation will CRC will applicable.
Motor Vehicle Act.
There is no provision, my lords. So far the limitation.
Yes, Mr. Naik.
Section 470 clause 3, where
417.
470.
Yes.
Where notice or prosecution of an offence has been given, or where under any law for the time being forced, yes, consent or sanction of the government or any other authority is required for the initiation of any prosecution for an offence, then the computing the period of limitation, the period of such notice, as the case may be, the time required for obtaining such consent or sanction shall be estimated. So now,
This is in there.
it is a prosecution report has been submitted.
No, it is not. The sanction is not required.
So that fact also is to be taken to note.
What sanction?
Sanction.
Sanction, no
sanction. No prosecution can be filed.
There is no question of.
Prosecution report has been filed after getting sanction.
You got the sanction.
This is the provision, so I have to take instruction.
There is no question of sanction, my lords, here.
Notice was issued to you.
No, only on this point. I have to feedback.
Issue notice. Mr.
Framed against her under 373, 376(3) and other offense along with the POCSO Act, Lordship. Here, my lord, in the meantime, the entire prosecution
challenging the cognizance order.
No, my lord, that is the charge, framing of charge, my lord. What
Charge
happened, Lordship? Yes, Lordship. So
Yes.
that the charge was framed in 2022, my lord. And also, in the meantime, all the witnesses, they have been examined, my lord. So no one has whispered a single word against the petitioner, my lord. Even if that also, this case is continuing, the court is not taking any steps to dispose of, close the case, because the lady and also he's coming to the court.
Where are the evidence?
The evidence I have not filed, but so the evidence copy with me, my lord. Entire evidence has been finished since 2023, my lord.
Where will I get that?
That's so I have got.
Where have you said in the petition?
Yes, I have said, Lordship, that the,
Where have you said?
I have,
Which
yes, Lordship.
Yes, para 6.
Yes, Lordship. That also.
I'll give it directly. Okay.
Yes, Lordship. Yes, Lordship. Direct Lordship. Or closer.
By invoking the inherent jurisdiction of this court under 482 CRPC, the petitioner is seeking. What is your direction?
Lordship, close the case. All the witnesses, they have been examined. All witnesses, Lords.
They are seeking quashing of the order dated 8/3/2022 passed by the special judge under POCSO Act in Raigada, NTR case number 78 of 2020, whereby the below has taken cognizance of offense punishable under section 9, whereby the court below has framed the charges against the petitioner for offense under section 376(3), bucket 506(109) IPC, reading section section 4 and 3A and 4(2) of POCSO Act 2012. The petitioner in the petition in para 6 of the petition contended para 6 of the petition. Para 6 of the petition. Mr. Dhar, counsel for the petitioner submits that all the witnesses in the present case has already been examined, and none of the witnesses have whispered a single word against the petitioner. Despite that, the trial court is not concluding the trial. Therefore, although he has challenged the order of charge, but you would not press the present petition. Rather, pray before this court for a direction for expeditious disposal of the trial. Direction for expeditious disposal of the trial. Next, regarding to the statement made by the petitioner and the ground urged in the petition, I feel it expedient to direct the trial court to do it, to see that the trial of the case is concluded. With this observation,
so I may submit once. So for this petition is concerned, my lord, because there are two petitioners. One is the absconder. Because of that absconder and this petitioner is suffering, my lord.
Whatever. Yes.
Lords.
May I please, Lordship. Lordship, I am VC. The FIR, the allegation against the petitioner is in the PX case number 270/2024, offense under section 115(2), 122, 296, 324 of the BNS. In the meantime, the FIR, this is a counter FIR. The main FIR in the CRLMC number 1157, Lordship already directed to the OP to appear in the court. So we are the OP in this case.
Which case? This case?
No, in the case I have noted CRLMC number 1157.
Where is that order?
compromise matter.
Where is that order?
That
Show me
order,
that-
Lordship, it has been passed by the Lordship.
Show me that order. How will I know? What is that order?
Only issue notice. It's a issue notice compromise. It's a compromise matter. So you have issued the notice. The same day it may come.
Where have you said that in a connected matter notice has been issued? Where have you said?
No, Lordship, this has been filed prior to that. That matter was listed before.
But you should have make a everment also. Where is that everment?
This is not the similar matter. That is in the FIR number 269.
Then why are you saying that?
This is
connected
270. FIR number 270. This is a case counter case matter, Lordship.
That's what I'm saying. In a counter case, this court has issued notice. Where is that?
Yeah.
Where have you said that?
I have not stated because this was filed.
You said then only. Otherwise, show me the order.
Yes, Lordship.
Neither you said anything, nor the order is there.
Yes,
And I issue notice tag this. Thereafter, it will be discovered that nothing to do with this case.
Yeah.
Unless you make everment, how will I take it?
Yes, it is on 27 to 2025. 27/3/2025. Your Lordship order. The pass by this Lordship.
Do you want that I should get the order for you?
No, Lordship, I'll be
Then-
giving this order.
What is this? There is no one who can appear. You give a date, then I'll keep on searching for you.
No,
This
Lordship.
is very unfair. Simply urgent. At least you should give that copy and something, or screen share the order of the court.
Lordship, pass out the order. I'll be.
Pass out. Yes.
Published.
116.
The standard is deteriorating day by day. It's very, very unfortunate.
Lordship,
Yes.
system kindly pass over there, Lordship.
Pass over.
17.
May I please? Challenging the order dated on 2025 May.
31.
1/2025 May. In rejecting my petition under section 311.
Why are you coming in all 311 petition? I don't know. In maximum cases, you move 311 rejected and come. Anyway.
It is in this case, my lord, the victim was not cross-examined at any.
Victim.
My lord, I have annexer 3, page 17.
25 years.
My lord.
Not POXO.
POXO is there, my lord, কিন্তু ସେ 6 ବର୍ଷ ତଳେ ରିଲେସନସିପ ଥିଲା ବୋଲି ସେ ପାଇଁ POXO ଲାଗିଛି.
No. Yes.
Page 10. Grounds has been, page 10.
Page 19, just see.
Page 9.
Decline.
Decline. ଜମା କ୍ରସ୍ ଏକ୍ସାମିନ କଲି କଷ୍ଟ ଦେଇ
ଦେଢ଼ ବର୍ଷ ପରେ ପୁଣି ଆଉ କାମ.
Oh, show me the application.
application, my lord. I have annexed it, my lord. Page 2, annexure 4, page 20.
Why have you not cross-examined? You have not said in.
Sir, advocate, my lord, সেটা তো লিখি হবে.
300 application as if it's right.
No, not a,
Handwriting application.
not a,
Call him.
not a right, my lord. Since, my lord,
The application.
not examine at any length, my
But
lord.
reason you have to give. Why have you not
My
done it?
lord, reason तो अब वकीलों को
Not
बेदोष
examined, declined.
हाँ decline वकीलों को दोष दे परिवेन ना लिखी परिवेन क्या वकीलों नार के भी लिखी परिवेन हो
Therefore, the court uses the word decline.
हाँ जी
Because declined by the.
Yeah.
But you have to give some reason.
रीजन है कौन है कहते विषय वकीलों तो ना decline कर दीजिए
Gee, what do you say?
Not satisfactory because after 1.5 years and after
ट्रायल तो चालीस ना ट्रायल सॉरी
See,
नहीं
the problem is she is now 25 years. Okay. Allegations are, I had relationship for 6 years and back. So 33.5 will not operate because it is not an absolute bar. 33.5 will operate. But she is now 25. I'll issue notice because informant is also there. I'll issue notice. Issue notice, sorted with your liquor. Okay. What is the stage now?
स्टेज में लड़ यही आउ दी तीन टा साखी ही चले
Okay. Sorted the issue notice.
I will file a liberty may be granted to
file an adjournment.
What adjournment? Let
No,
the other
sir.
evidence go on. How does it make difference?
Sir, sir, Devedan.
Within the surgery because you came here.
No, sir.
I will put it next week.
I will serve copy.
Okay, save a copy and informant also you have.
Informal notice, my lord, I am not made in party.
You have made it the party. You have made the party.
I've
seen it.
Not address from the
Address देवा को दक्कर नहीं तब अपन पठे देवे. Through IAC को दिया. Service through IAC as well. ठीक.
Problem.
18. No.
18 minutes. I'm
Yep,
sorry.
you're there, sir.
I thought this is.
Yes.
Well, it's 18. Here, what has happened, Malcolm? On the petitioners are the father-in-law and the mother-in-law. I mean, the parents of the husband.
Yes.
And only on omnibus allegations, my lords, they have been implicated in the said case. My lords, your lordship, if your lordship sees the FIR.
Yes.
A lengthy FIR has been lodged by
Let us
the.
come to the charge sheet. What are the allegations? Charge sheet allegation. Matrimonial.
Yes.
Matrimonial.
498 and all.
498A, my lords. No evidence against the, my lords, no evidence of torture against this, only.
And issue notice matrimonial.
And my lords, Supreme Court, in a recent judgment of Kafkashan Kausar, they say that these are.
What is happening in the marriage front?
My lord,
Marriage front.
divorce has been filed.
Already filed.
Filed. And my lords, the the husband and the wife, they were. Torture has.
All this culture has started now.
Yes.
Because the boy and girl goes there and they marry there and they fight there and the parents are
Implicated. My lords, it seems the allegations
this
are.
culture has come very.
I have telephoned over phone and that has been noticed, judicially noticed by the Supreme Court, my lords.
Which one? Which paragraph? You have?
My lords, para 14, from 13, my lords, your lordship says.
Yeah.
Paragraph 13 at running page 605.
Yes.
Your lordship gets it?
13, yes.
Previously in the landmark judgment of this court in Anish Kumar versus State, there's a phenomenon. Increase in matrimonial disputes in recent years. The institution of marriage is greatly revered in this country. Section 498A IPC was introduced with the avowed object to combat the meanness of harassment to a woman at the hands of her husband and his relatives. The fact that Section 498A IPC is a cognizable and non-bailable offense has lent it a dubious place of pride amongst the provisions that are used as weapons rather than.
Para 17. Para 17.
Para 17, my lord.
Yes, it takes Anish Kumar, Preeti Gupta,
yes, my lord.
Geeta Mehrotra, and thereafter para 17 come.
Yes, my lord. The aforesaid decisions clearly demonstrate that this court has at numerous instances expressed concern over the misuse of 498A IPC and the increased tendency of implicating relatives of the husband in matrimonial disputes without analyzing the long-term ramifications of a trial on the complainant as well as the accused. It is further manifest from the said judgments that false implication by way of.
I got it.
General omnibus allegations.
You are challenging cognizance order.
Malak?
You are challenging cognizance order.
Yes, well, challenging the cognizance.
The petitioners are the mother-in-law, father-in-law.
The mother-in-law.
Mother-in-law, father-in-law of opposite party number 2. I have been implicated by the opposite party number 2 in Mahila PS case number, Bhubaneswar Mahila PS case number 165 of 2024. After investigation, charge sheet has been filed in the present case on 30th November 2024 for alleged commission of offences. Page 20. Page 20. The trial court by order dated the trial court the SDJM Bhubaneswar by order 3/11/24 in CT case number 1910 of 2024 has taken cognizance of offences punishable cognizance of offences above against the present petitioners and their son, who is the husband of opposite party number 2. Mr. Kango, senior counsel appearing for the petitioner, has taken me to the allegation made by the opposite party number 2 against the present petitioner. The allegations are omnivorous in nature and very omnivorous in nature and without any basis. He has also relied upon a judgment of the Honorable Supreme Court reported in 2022 6 SCC 599. पुरानी जो कासब क्या है Kasar versus state of so and so. Para 17 of the judgment, the Honorable Supreme Court by taking note of the judgment of Arnesh Kumar, Bihar, Preeti Gupta versus state of Jharkhand, and Geeta Mehrotra versus state of UP has arrived at the following conclusion. Para 17. Issue notice to opposite party number 2 written so also in the shall I send it to mediation straight away?
Your lordships may.
Regard being head to the nature of allegation and the fact scenario of the present case, I'm of the considered view that the parties can explore the possibility of out of court settlement. Hence, the matter is referred to High Court Mediation Center. High Court Mediation Center. High Court Mediation Center. The coordinator of the High Court Mediation Center shall fix a date and communicate it to all the parties concerned. And after exploring the possibility of settlement, file a report being called. Awaiting the mediation report. Mediation report leaves the matter after 3 weeks. In the meantime, proceeding before so and so state.
Oblige.
Yes.
Oblige.
Yes. 19. 19 Corridor.
Order of cognizance, my lord. On the ground, the annexure 1, same ground, the annexure 166 complaint case under 138 filed by the present opposite party no 2 against the present prisoner. After 2 years, he withdrew the same during pendency of the trial matter. Thereafter, after 3 years, he managed to lodge one FIR against me. Same allegation. And cognizance was taken, my lord.
Cognizance, there must be something there for cognizance.
Yes, man, he allegation my two think two different complaint good story, FIR good story.
Criminal cases are on the basis of stories only.
Yes, man. And
that story has to establish.
Yes, man. We shoot 6 checks. And therefore, it insufficient fund 130 enact.
What are the offences by the way?
420,506, man.
I'll simply issue notice. Bring him. We'll see. Issue notice. Bring him.
This case,
there is no. I can't interfere because there are allegations.
Yes, issue notice. If adjournment petition ladies, my lord. If adjourn that
is the lady.
Yes, my lord. That is distance is my lord 200 kilometers.
19,
58 years.
Let us see the allegation first of all.
Yes, ma'am.
Annexure?
Annexure, my lord. Annexure 3, my lord. Page, your lordship, kindly page 63, my lord.
63.
FR.
Yes.
Occurrence in the year 2021, my lord. It's alleged that in order to provide canteen aims Bhubaneswar, my lord, petitioner took 57 lakhs and he returned 5 lakhs 50,000 and issued 6 checks, my lord. This is allegation.
Annexed to one series.
And about the same check, the here.
Yes, yes, annexed to one series.
And withdrawn.
And one series. After 2 years, it was withdrawn.
Let me move application for adjournment.
Obliged.
I'll just come.
In one case, I am the petitioner. And in the first case, I am the opposite party in the third case, and that has been settled. And the complainant has filed the first 482 for passing of the proceeding. And that I have also filed a 482 for passing of the proceeding, and they are present.
Same.
Same. They are present in the court, my lord.
What are the offenses?
Doctor could insurance that has been returned.
Yes, have you verified? This is isolated case or many other cases? No, this is only isolated case or any other complaint is pending against it?
Only a isolated case.
Yes. Let us see the allegation. Let us see the allegation. First item I'm picking up. First item is yours.
No, first item is
the complainant is filed.
Because he has got the money and matter has been settled amicably between them in interval.
Second matter is the.
I have filed those are accused person, they have filed.
Okay, let us see the allegation. Yes.
First item is annexure 1. Annexure, sorry.
Tell me the allegation. What are the allegations?
Allegation, my lord.
Robinson.
Paragraph 3.
Yes.
1,30,362 crop insurance has been taken by the accused persons.
Crop insurance. 1,30,000.
In the name of Belandri Majhi.
Okay. You take the second matter. Second matter first. Huh? Second matter is the accused person. Second matter first. At the instance of opposite party number came to be registered against the petitioner. After investigation, charge sheet has been filed in the present case on 16/1/2024 for alleged commission of offences 17 under section 4.350. The cognizance is taken. The trial court has taken cognizance offences as mentioned above. While it's order in a subdivisional SDGM Dharamgad has taken cognizance of offences as mentioned above. By order 16/1/2024 in city case number 506 of 2023. Allegation against the petitioners para 3. The petitioner and the opposite party number 2. All the petitioners.
All the petitioner informant. One petitioner is in BC. Others are.
And all who is in BC? Petitioner number.
BC. Bindu.
The petitioner
Plans the affair that is as per 8. Your lordship may 5-line affair. Lordship may kindly see. First of all, I would like to draw your lordship's kind attention to date of the affair. The affair is drawn on 5/9/2024, and your lordship may kindly see what is written that I have already filed the affair on 22/9/2024. The affair is itself on 5/9, but she has written in the affair that
where are you reading?
Yes, page 8, my lord. The affair.
Yes.
Yes.
आज्ञा proprietor of
बकेया अर्थ प्राप्ति 22/9/24 रे योर लॉर्डशिप दैट इज रेलेवेंट 22/9/24 रे एफआईआर बकेया अर्थ 22 सत्यव्रत आज्ञा विरोध रे एफआईआर करथिली दीर्घ दिन बीती जायथिला मध्ये से बकेया टंका 3,10,260 टका न देई धमक दैछन्ती दिस इज द एफआईआर सब्सटेंस सम एंड सब्सटेंस ऑफ द एफआईआर द लॉर्डशिप द एफआईआर इज अनडेटेड 5/9/2000. That is 5/9, but she has filed 5/22/9. Where is it? That is that. And that particular
13/11/2024.
FR is 5/9. That your lordship may see above the Bhubaneswar. Sir, Unodiya. हाँ, Bhubaneswar ऊपर को लिखा है जोड़ा 5/9.
What is the annexure 1 then?
This is the FR annexure what?
That is registered on 13.
That is registered, yes. She said the affair, the cause of action arises at Bhubaneswar. She scribed the affair at Bhubaneswar and sent it through post to the Bangiri Posi of Morgan district. Cause of action at Bhubaneswar. They filed it through a registry post.
Oh,
It was registered.
small things.
Yes.
Investigation is going on.
My lord, your lordship may
Why don't you have taken the money paid?
No, my lord, the money has been paid. Your lordship can see answer 3.
3,10,000.
Your lordship can see. Here she is saying 3 lakh.
What is that pre-litigation mediation? Kya? What is this?
सही तो कथा प्री मेडिएशन रे कहउछन सी है जे 4 लाख लॉसी में काइंडली सी पेज 11 ले 4,10,260 एठी कहउछन 3,10,10,260 so this is the amount substance एटा जे कहउछन किंतु
How, where from I'll get that you have paid?
that is answer 3 matter जो receipt paid your lordship can see that is as page 14 lordship paid by me, that is the entire the receipt, and the amount is 13,25,400 and he has paid, so nothing there. But you know to what has happened, in fact it's a case mirror so where the
Tell it to IO would take.
it is not at all, it is never a case mirror so doesn't
Issue notice letter.
no
Some money might be.
No, my lord. No, my lord.
Pay and finish it up.
No, my lord. Nothing. Not a single pie. So,
now I have got 3 figures. One is 3,10,000 and 4 lakh something.
Yes.
Now 13 lakhs, which is correct?
13 lakh is the amount.
That means a continuous dealing is going on.
No, no, sir. 13 lakh I already payment कर दीजिए ना. मुझे देला पर मुझे जिनसे देले.
If it is 4 lakhs,
My lord.
3 lakhs,
Yes.
10,000 claims.
Yes.
Why have you paid 13 lakhs?
No, bill 13 lakh 13 lakh जिनसे नहीं
There
दीजिए.
is something in between.
No, my lord. Nothing.
Cash.
ये मागिल है. sir.
Cash dealing, pay.
My lord, cash is already paid. So your lordship may kindly appreciate.
I will issue notice, let him come.
I am
You have to pay what?
ना किसी नहीं आ गया किसी माने टंकड़ी भी नहीं से आमे जतले लगेले से किर्लोस्कर जो ये कोन कहले रेफ्रिजरेशन जो ये कोल्ड स्टोरेज दा कहला भी इंस्टॉल करो बोली से कहले इंस्टॉलेशन चार्ज फ्री हबो एबे कहजन पैसा दियो सही कहजन कहजन 13 लाख टका नै जो 13 लाख केतना दे दी
लिखाई
ना सर लिखि नहीं से किन कहजन
Charges they are
कहजन सर
I'll tell you what happened.
Yes.
The installations are being done by outsourcing. You purchase from Kirloskar company.
Yes.
They outsource someone to install. The outsourcing company will collect.
No, she herself. She herself is installing. She कोई से यार. कौन बोलता है? Matters.
Investigation is going on. What can I do? I stop investigation. How do I know? File the process immediately.
Yes, madam. So within 3 working days.
Shall I dispose it up for directing the IO to?
No, it's not. No, not. It is civil notice. Notice go. ठीक है. What to question? Okay. से 80 भी नहीं आई है.
21. Your lordship may call this matter on 23rd April. Parties will appear before your lordship.
What is this matter?
It is offence under section 363 IPC. Number 2 is the informant and 3 is the victim. My learned fire has the instruction to appear. And now they
you have fixed a date according to your choice for the convenience of the accused or for your convenience. Better you say that for your convenience I will accommodate, not for the convenience of the accused. The accused will not dictate the court when he will come and I will take it.
No, not for the accused, my lord.
Then why are you taking the telling? See, he will come and take it. What is this submission? What is this?
Your lordship may fix, my lord.
You take back your statement. High Court is not under any accused. How are you saying that accused will come fix a date? What is the submission? Don't deteriorate the standard of the High Court. We are not subservient to the accused.
Sorry, my lord.
You can very well say that I have some problem. My lord, you take it up on such a day. I will be graceful. I'll take it. The court can accommodate the lawyer, not the accused. Let him attempt to come on 15th. Let him come on 15th or I will dismiss with cause. 15th. Please 15th. There's a first item. Let him come.
My lord.
Otherwise, I will dismiss with heavy cause. Because you have honestly submitted because your client has told you that I'll come on 23rd.
15th.
Isn't it or not?
Hello?
Your client might have told you on 23rd I'll come, go on date, get a date. Honestly, you came and told.
He did not tell a date, Miller. I honestly speak. He did not tell a
The date is given by you or given by the
by
client?
me. With great respect by me, Miller. This is my fault. Lekin,
Never do that. Never do that to any court. Never ever do that. Okay, 23rd. It is your inconvenience, then 23rd. No problem. Okay, 23rd.
I talked to my learned friend. He is not available on 24th. That's
For
all.
your inconvenience, I am ready to accommodate. But if the accused is dictating,
No.
that
But
I'll
he
come
is,
to 23rd, please tell the.
but he has
court
not
to
even
take up-
said, Milord. He has not even said that.
Then it's all. Then it's all.
We talked that this will be this date. Both will be present.
Okay,
For which
you
we
have to
tried,
think
Milord.
23rd I'll give. But tell your client not to dictate.
No, he has not told anything.
Okay, it's all right. 20.
Grateful, man.
23rd. Okay.
22.
Yes.
I'm filing this application for passing of the FIR on the ground of compromise.
What are the offences?
That offences are at 329 of subclause 4 of the BNS 296.
What is the stage now?
Now the investigation is not completed, Malarsi.
I'll issue notice.
Yes, issue notice.
Issue notice.
I am for the informant.
Disturbance in the.
I am for the informant.
How many accused go offering?
Malarsi, that is the dispute between the village, Malarsi. That actually the story is that Malarsi, that the present informant is taken handled on from the Mangala Matsuyajivee committee, and then when the committee is demanding the money, he did not return the money, and then the dispute arises, and the in the presence of the village entry.
How 14 accused were?
Yes, ma'am.
Who has taken the money?
That 14 accused person, the member of the committee, Mangala Matsuyajivee committee.
Okay.
That the informant is taking money from the committee. In the year of COVID, in the pandemic.
He did not return, therefore refile a case.
Yes, ma'am. Okay. That is the case, ma'am. And in the meantime, the village dispute is already resolved, ma'am.
I'm for the informant.
Yes. As soon to entered appearance, file which is taken on record. File joint affidavit and all everything.
Fix a date, then
fix a date. 23 you come with the other accused.
23. I beg pardon, I'm requested kindly fix a date on Monday, Thursday.
No, next week it's not possible. These 3 days are very, very tough.
Any
24th, huh?
24. Yes, ma'am. Yes, ma'am.
24.
Obliged.
Bring them. Okay.
Item 23.
Wait a minute. ভুল বুঝামଣାରେ কেসটা ହେଇଯାଇଛି ଆକ୍ସିଡେଣ୍ଟ ହେଇଥିଲା ଏମାନେ ସାହାଯ୍ୟ କରିଥିଲେ
କେସ୍ ତ
ନାଇଁ ସେ
ଭୁଲ ବୁଝାମଣା ହୁଏ ନା
ଇନଫର୍ମାଣ୍ଟର ସ୍ୱାମୀର ଆକ୍ସିଡେଣ୍ଟ ହେଇଥିଲା ଏ ତ ବାଗେଇଲେ ତାକୁ ଉଠେଇଲେ ତାକୁ କହିଦେଲେ ଯେ ତୋ ସ୍ୱାମୀକୁ ମାରିଛନ୍ତି ସେ ଯାଇକି
what are the offenses let us
offense 172 she has appeared my lord informant has filed affidavit ଭୁଲରେ ହେଇଯାଇଛି ମତେ ପୋଲିସ ଷ୍ଟେସନରୁ ଯାଇଥିଲା ସେ କହିଲେ ତମେ କୋର୍ଟକୁ ଯାଅ ଆମେ ପଠେଇ
what is
ଦେବୁ
the corresponding section there in IPC let us check it 117
hot ସେ ଆକ୍ସିଡେଣ୍ଟ ସ୍କୁଟର ଆକ୍ସିଡେଣ୍ଟ ତାକୁ ଇଏ ଭଲ କଲେ ଫାଷ୍ଟ ଏଡ୍ ଦେଲେ ତାକୁ କିଏ କହିଦେଲା ମଜାରେ ଯେ ତୋ ସ୍ୱାମୀକି ମାରିଛନ୍ତି ଏଫଆଇଆର ଦେଲା ପୁଣି ଯାଇ ଉଚ୍ଚ କରିବାକୁ ଯାଇଥିଲା ସେ ଫାଇଲ କରିକି ଆସିକି 2 ଜଣ ୱାଇଫ ହଜବେଣ୍ଡ ବୋଥ ଫାଇଲ ଆଫିଡେଭିଟ୍ in this case.
Okay. Yes, Mr. Naik, what do you say?
Yes, notice.
Notice actually already se appear kare. Ha. P2. Copy no na. ତଳକୋଟୁ ଗଲେ 4-5ଟା ଡେଟ୍ ହେଇଯିବ ଅନନେସେସରି କିଛି ନାହିଁ କାହିଁକି ସେଥିରେ ଯିବେ ଚାର୍ଜ ସିଟ୍ ଫାଇଲ ହେବ କେତେ କଥା ଅପେକ୍ଷା କରିବାକୁ ପଡ଼ିବ 22/6 ଡେଟ୍ ଅଛି
Yes. Read the allegations.
Read it. ଶୁଣିକିନି କରିଦେଇଥିଲା ସେ ଶୁଣିକିନି କରିଦେଇଥିଲା ସେ ଭୁଲ ମାଗିକିନି ଲେଖିକି ପୋଲିସକୁ ଦେଇଛି
Show me the injury report 325.
Sir,
grievous hurt.
Sir, କିଛି ହେଇନି ସେଥିରେ ଖାଲି ଏଫଆଇଆର ହେଇଛି
Acha, FIR only. Investigation is going on. 325 only.
ଗୋଟିଏ ଲାଇନ ଲେଖା ହେଇଛି 22 ତାରିଖକୁ ଫରକ
Okay. Where is the petitioner? Where is the petitioner?
Petition, sir.
3 petitioners. All the 3 of them are there.
Today they have not come. If my lord fixed date, they will come.
I have already issued notice.
No, notice.
Simple issue notice. fixed date.
23 तारीख ହେଲେ ବି ସୁବିଧା ହୁଅନ୍ତା ସାର୍ ପଳେଇ ଆସନ୍ତେ ସେ ସମସ୍ତେ
All accused persons have decided to come on 23rd only.
minor and also informant will come. Informant and her husband will come.
Okay. 23rd.
Right.
24.
Your Lordship, also same pair. Offense under section 451, 294, 323, 506. Title 3 of Lordship 1 and 10 SCST Act.
Yes.
Lordship, here all our students getting Panivia University and due to some Lordship. Hostel bhitar, due to now they all have been Lordship. Come to.
I am appearing for the informant.
For my Lordship.
Is it ragging? Ragging?
No, not ragging. Yes.
Because the
Ragging.
informant is a first year student.
Lordship.
What about you?
No, Lordship, same classmate, Lordship.
Same classmates.
So, same, sir. All our friends, Lordship.
Let us see the allegation.
ମୋ ରୁମ ରେ ଶୋଇଥିବା ଅବସ୍ଥାରେ କେହି ଛାତ୍ର ମୋ ରୁମକୁ ଧକ୍କା ମାରିବା ସହିତ ଅସହ୍ୟ ଭାଷାରେ ଗାଳି ଗୁଲଜ କରାଗଲା। ମୋ ରୁମ ଖୋଲିଲା ପରେ ରୁମ ଭିତରେ ବସି ଆକସ୍ମିକ ଭାବେ ଲୁହା ଛଡ଼ ବାଡ଼ି ଏବଂ ବିୟର ବୋଟଲରେ ମତେ ଆକ୍ରମଣ କଲେ। ମୁଁ ଏହାକୁ ବିରୋଧ କରିବାରୁ ମତେ କହିଲେ ତୁ Lordship I be their caste and Lordship rejected the FIR, Lordship. And they have come up with a compromise petition, Lordship. And they are
Gukha is schedule.
Gukha ne Kondra likchinti Kondra.
Belongs to Gukha.
Gokhada it is Gokhada we had it. Sorry. No.
Gukha is the schedule.
Schedule caste. Gokha is.
The students have to pay some price. How to?
Just qualify for each Lordship. What to Lordship?
I'll pass it, but
Lordship,
they have
because
something.
all time it will Lordship. Now all our Lordship passed out, and then they today also they are ready to appear in VC. And
Where are they?
No, Lordship, I will not. They are ready.
Okay.
Lordship.
Okay.
If Lordship fix it,
again on 23rd because the other co-accused are coming.
Lordship, that will be busy day, Lordship. Next week, any day, Lordship, they will come and appear.
21st, 22nd.
Lordship.
22nd.
Lordship, any day, Lordship.
They are students, in fact.
Students.
College, something happened.
Yes.
Lordship, yes.
Shall we make one copy? 22nd.
25.
Lordship, can we be protected for that? Lordship, on that date? What?
Nothing is going
Lordship, nothing will happen.
They will not be arrested. They will be trouble for the police also. They will not take it. Yes.
No course of action, Lordship.
Nothing will happen. 22nd, 21st.
That's full, Lordship.
Yes. I was that day. I was bringing all of them.
Lordship.
May I please, Lordship, item 25. Here we are challenging the discharge order rejected by the learned court, Lordship. Lordship, offense is under section 10 of POCSO.
Why should it be this?
Lordship?
Why should it be allowed? Charge has been framed.
No, not yet, my lord.
Huh?
Not yet. Charge has not yet.
Your discharge application is done now.
My discharge has been applied.
Tell me the.
Lordship, kindly see the allegation is overhead allegation, whatever, Lordship. The informant called the victim, called a call letter for over phone call. The father of the victim called him and telling the petitioner assaulted the victim child, which is baby boy, little boy, 13 years boy, my lord. And after the verification, after the informant called get the call, they verified the CCTV camera and she found it that the petitioner entered the hostel room and they just out it. That is only the overhead allegation, and the rest of the part relating to the statement, Lordship. And the statement is completely contradictory. That is.
No, see, you are 54-year-old.
Lordship, he's the warden, Lordship. He's the warden.
That is the reason I'm not going to question.
Lordship,
I have to write so many things, then you will be in trouble.
No, my lord.
Allegations are very serious. Just see, your order, warden, what have you done?
Yes, my lord, sir. I have already gone through there.
How are you moving this application? This kind of perpetrator only the POCSO Act is enacted. You are 54-year-old person and you warden in the hospital and CCTV footages are there. Just see page 21.
Lordship, the CCTV footage that is just clear. He entered the.
I'm not going to value upon all these things. You withdraw it better. Otherwise, I will have to write something then. Then counsel for the petitioner seeks to withdraw this petition to raise all the points before the court below at a this liberty petition is disposed. Yes.
Yes, my
Yes,
lord.
sir.
The petition filed with a prayer for quashing of criminal proceeding, my lord. All offences are compoundable and triable by magistrate first class.
Then go file
And
it.
the petition filed on the ground of compromise. The matter.
Compromise 482 doesn't lie. If it is compounding offences, you have to go and file there.
My lord,
320
my lord,
CRPC.
yes, madam.
You
Problem is
remove
that
application.
now investigation is going on and other offences.
So therefore,
might be
320 you
add,
file.
my lord.
320 you file application.
My lord, there is a problem, my lord. Because of the informant and accused person already.
Why should 482 court will interfere if it is a compoundable offences? 320 we will take out from the statute book or what? You move application at 320 and get it. How it is maintainable? Withdraw right off. Counsel for the
Your lordship, my kind direct to file for that liberty for that
That's what I'm
petition.
saying. Then counsel for the petitioner submits that item with letter 55, 26. The petitioner is seeking quashing of the FIR registered against him, registered against them by the opposite party number 2 for release of then counsel for the petitioner submits that he will withdraw the petition to resort to the right remedy under law. Because all the offences either against the petitioner are compoundable in nature. With this liberty, the petitioner is quoted. Yes.
And my lord, your lordship, my kind in the meantime, no course against the petitioner.
Compoundable offence. You are withdrawing.
My lord, police तांको टिके हैरान करछि ए माने दी जण पट्टी गलेडी
Police arrest करे पे किछि पे करछि करतो सर. That I can't tell you.
ने अरेस्ट करबा में सने घर
No, I will not arrest. Compoundable offence, small offences. Why the police will be? Yes.
your lordship, my
I can't do
kind
it, sir, because 482 is not maintainable.
no course action shall be
I
taken.
can't
Please
pass that
file
order
the
because the petition is not maintainable. Therefore, I am giving you liberty. I can't do that. Otherwise, I would have done it.
However,
27.
they bhala है
Lordship, sorry to Lordship. 19 to 27 तक OS exam चल civil service exam पिला उड़ा करते हैं.
Okay, then what do you want?
पूर्व ही पर
17.
Grateful Lordship.
17.
Grateful.
No, item 27.
24.
Yes.
My lord, quashing of the cognizance matter. My lord, in the meantime, another coagged person. Order has been first or second of my lord. Kindly see. How first or second of the superintendent? It says that
Same.
Say
He doesn't want to press with that.
Say cognizance order is I
Although the petitioner has challenged the order dated 27/12/2021 passed by learned JMFC Basta in CT case number 666 of 2021, whereby cognizance of offences punishable under section 312 section has been taken. But the petitioner doesn't want to press this petition. Rather reserve his right to agitate all the issues before the court below at appropriate stage. Let the counsel for the petitioner further submits that the co-accused persons had approached this court by making the similar prayer by filing CRLFC number 526 of 2023. The coordinate bench of this court filed order dated 24/2/2023. Directed the petitioner therein to surrender before the court below and apply for bail. Bail. Apply for in case the bail will decline, they have a liberty to approach the higher court, higher forum. The operating part of the order dated 24/2/2023, passed in CRLMC 526 of 2023, reads as a para 2023. I submit that the present petition may also be disposed of in the present petition disposed of in terms of the order details also.
My lord.
Yes.
28.
This case, my lord, the petitioner challenging the criminal proceeding, my lord, on the ground, my lord, while the discharging of their official duty, my lord, the present complaint case was filed, and without sanctioning, my lord, the learned court will have taken cognizance, my lord.
What are the allegations that are seen?
Allegation complaint petition is under Annex 1, my lord, page 14.
Tell me the allegation.
Allegation is that much. Paragraph B, my lord.
Yes.
That the accused number 1 become furious and abuse.
You have filed 2 FIR. Which FIR you are concerned?
No, my lord. Yeah, that are the later phase. First is the complaint petition, my lord. Yeah, in what happened, my lord, in this case, my lord, due to village dispute, my lord, there are 2 FIR has been lost, my lord, against the 2, my lord. And the present opposite party, he is a stranger to this case, my lord. He has no local standing to file this case. He went to the police station, my lord, in respect to the FIR number 2nd FIR, my lord, to influence the present petitioner, my lord.
Yes.
To make out a case under 307, my lord.
What are the allegation against you?
Allegation is, my lord, that on 21/8/2023 at about 6 p.m., the complainant, along with other witnesses, went to the Dabunga police station. At that time, the accused number 1 was standing in front of the police station. Thereafter, the complainant politely requested the accused number 1 to take action against the erring person of the Hon'Ble Harijan. After that, my lord, the accused number 1 became furious and abused in filthy language, my lord, and assaulted him by means of a slap and fist blow. By the time of occurrence, my lord, the accused petitioner number 1, he was ASI of police, my lord.
I'll issue notice, let us.
And during discharge of official duty, my lord, the present case has been instituted.
Official duty, you are police officer, you are going somebody's house and...
No, we have not gone. They came to police station.
You're physically attacking someone and official duty.
That is the allegation. There are 2 FIR has been lost, my
That
lord.
is allegation only. The allegation is coming under the color of duty.
Yes, my
It
lord.
doesn't come under the color of duty.
Yes, my lord. Still then, my lord, 197 protect, my lord, as per the latest judgment of the Honorable Apex Court. Even if excess, my lord.
Yes.
If there is some reasonable cause, my lord.
And the custody, the excess, use of excess power. You were in the custody.
No.
You're not in custody.
It is not custody. They came to the
If
police.
this judgment says that if in custody, if you have used excess force,
my lord,
against the person who is in custody, then also 197.
If there is some reasonable cause,
but you go and do something outside, it is coming under color of duty. What are you talking?
No, my lord. They came to the police station, my lord. They came to police station. They
where they in the custody?
Not custody.
Why? Show me where they were in police station. Where is that?
The complaint petition, my lord.
Yes. Which page? Page?
Page 16, my lord. Yes, my lord.
Okay.
Page 16.
What?
Paragraph IV.
16, huh?
Yes, my lord.
Okay. Read it.
That on 21/8/2023, about 6 p.m., the complainant, along with other witnesses, went to the Dabunga police station.
Right.
At the time of the accused number
They were in
was
police station.
Dabunga police station.
The petitioner is seeking quashing of the what are you seeking quashing of?
Quashing of criminal proceeding.
The 1 CC case number 13 of 2023, which is pending in the court of JMFC Umar Court, initiated by the opposite party number 2. The allegation, Mr. Mishra, learned counsel for the petitioner, has taken me to the precise allegation made in the complaint in para Roman 4, 8 Roman 4, which reads as under Roman 4. He submits that the the complaint itself discloses that the informant was in the police custody, and the petitioner, being a police officer, has exceeded his.
There are three.
And what is the expression used here? Exceeded.
Petitioner number 1 and 2 are the ASI of police, and
One and
petitioner
two
number
are
3 is the home guard.
They have assaulted him while in custody by exceeding their authority, or exceeding their authority. Mr. Mishra, by relying upon the judgment of the Honorable Supreme Court in criminal appeal number 458 of 2020, D. Devraja versus OEC Saber Hussain, in para 77 and 78, submits that sanction under 197 CRPC was essential to prosecute the petitioners, prosecute the petitioner. Para 77, 28, this notice also. In the meantime, petitioner is at liberty to move application for the trial court.
Stay for the proceeding. They are the government.
You move application.
Stay. They are the government employee. All our notice has been issued for appearance.
For the yes.
29.
Advance copy you give. You have to get instruction. Because see, the in one paragraph it is very specifically said that they went to the police station. In the police station, he was beaten up, and he is relying upon a judgment. It directly covers his case. 197 sanction is required. Anything happens in the police station, give the copy and give the judgment also. Yes. Item
29.
Kindly see page 15, madam. This is the complaint of the ED. Annexure 2.
15.
Page 15.
Yes.
My lords have it, minutes.
Yes.
This is a complaint under 45.
Yes.
And if your lordships kindly see page 17 minutes. It
Yes.
says FIR number, complaint number, police report.
Yes.
Of the scheduled offense and the place, court where it is tried. See the first line here. That the FIR number so and so. Kindly see FIR number and date is 9/4/2018. My lords have it. In the very first line.
FIR number so 9/4/2018.
I'm grateful.
Yes.
Now kindly see me.
Has been registered in the CBI so and so. Yes.
Yes, yes. Now kindly see page 75.
Yes.
Page 71, if your lordship sees.
Yes.
The page 75. No, I'm sorry, if your lordship says 75. This is the quashing order. And
This is the FIR you are seeing.
Yes, yes.
9/4/2018.
Yes, kindly see page 102 now.
Yes.
Para 25. Kindly see not according in light of the following judgments of the Honorable Supreme Court.
FIR number so and so 9/4/2018.
Same FIR, your lordships have quashed.
Yes.
That's the short point.
Yes. Okay. It is.
Also kindly see the page 50.
50.
I have to verify, yes. Page 15, annexure 2. Because complaint has been filed against number of persons below.
Yes.
Page 50. Your lordship has quashed the FIR with respect to accused number 1.
No, not like that. The whole FIR has been quashed.
Regarding accused number 2, 3, 4, they are.
Page 76. Page 76.
That's why I have to verify what others do because there might have been filed supplementary charges, so we have to verify.
Okay. Okay. It's notice.
Your lordship sees page 76. The judgment. It is in respect of everyone. But anyway, let him take instructions. I have no difficulty. I was only saying that.
These are PMLA. We don't know how the links have started. So far as the petition number 1 is concerned, it can be quashed straight away. No problem.
No, it is for petition.
I'll stay the proceeding.
Yes, but I'm only suggesting, but I'm only suggesting, let's say fix it after 10 days. We'll let matrimony disclose. What is the point in it?
At least, my lord, I will, because the IO has been transferred, new IO has come.
Okay, 2 weeks have time. Mr. Porizar, land counsel for the petitioners are seeking quashing of criminal miss bracket PMLA case number 11 of 2023. 2023 pending before the Court of Special Judge PMD Bhubaneswar. Bhubaneswar, on the ground that the schedule offense has already been quashed by this court by the judgment dated 13/2/2025 in CRLMC number 2091 of 2020. Relying upon the para 25 of the aforementioned judgment, which reads as under Mr. Parija submits that the FIR number FIR number so dated 9/4/2018 in toto has been quashed. So in view of the fact that the schedule offense has been quashed, the proceeding initiated by the opposite party under section 45 of PMLA substitute in view of the judgment. In view of judgment shown.
382.8. Para 382.8.
2023 12 ACC page number
382.8.
page number 1.
Para 382 minutes. Para 382.8.
Vijay Madanlal versus
I will give it to you.
India. Parija has relied upon para number 24. His case. Issue notice. Mr. Agarwal accept notice. And I shall I say qua the petition? Okay.
The next date is on 8th of. If your lordships are having it in 2 weeks after, then.
You move the application, they move an application for seeking adjournment in view of the fact that the matter is sub judice before this court. Lease the matter after 2 weeks.
Your lordship will fix a date.
Second May.
That's all. Second May is beyond 2 weeks. Yes. Let it come on second.
Or 5th May. Monday. 5th May. Okay. Wait. Yes, Mr. Draft case check what? Yes, no? Cost of it, okay. That's what I like.
Item 30.
Please, my lord. I'm appearing virtually, my lords. My lords, herein the petitioner has been convicted under section 307 for 10 years and 326 of IPC for 7 years, my lords. The appeal has to be admitted, my lords.
Sorry?
My lords, this has come for fresh admission, my lords. Appeal has to be admitted, my lords.
What do you want? Criminal, this is
file of state that the notice is issued, but my representation also that appellant is in custody, 10 years punishment, 0.7. But yesterday my guardian senior has mentioned that for relation of stay, notice has been issued to the appellant. How is it possible? He is inside in custody.
No, recovery of the.
Fine amount, my lords.
Where is that order? Where is that order issuing notice? I'll issue notice.
My lords may stay the fine amount and admit the appeal.
Okay. Appeal admitted. Where is the application? First thing.
My lords, IA number 831 of 2025.
831. 831. The recovery of the fine amount is the state. In the next step. Okay. Fine amount is state. I'm not giving bail. I'm not. Yes.
31.
Legal lordship, my lord. This is appeal. It is the investment of 3 years and fine of 60,000.
3 years. Okay. Admit. Okay.
What is matter, my Teaching matter.
He is the seventh accused and appellant, and all other 6 appeals have been admitted by.
Give the number.
I have already given the number.
Okay. Tag it. Take it. Yes.
32 for
30.
bail and stay readers of
Yes.
accused.
Wait. Yes, 32.
32.
It's 30.
3 years. Okay. Same
3
out. Admit.
3 years.
Yes, admit it. Yes.
33. If you get the employment, I put the 24, get the employment. If case is ported to appearance, you will not have the employment issue.
5/4/2024. Okay. Yes.
I pray
Yes.
for local bar association.
Local bar.
34.
That is right. I have a glance at next of page number 17, Mala. On 25th March 2025, owing to the non-appearance of the petitioner, Mala, at the stage
You
of
tell me the bail date.
NPW has been issued, Mala.
I know that bail date. Where bail?
Mala, on 8/7/2024, 205 petition was allowed, Mala.
Okay. 205 right. Okay. Yes. Yes. Next.
35.
My lord. And she was on bail on 4/8/2022.
4/8/2022.
22.
Okay. 12/12/22. NBW. Okay. Yes.
36.
Let's say NBW was issued against the present petitioner on 4/3/25.
Yes.
Petitioners were released on bail on 73/2020.
22.
20.
20.
20.
Yes.
4 petitioners.
Yes. 4 petitioners. 5,000 each. Yes.
37.
Yes, sir.
Civil miscellaneous petition. Order impugnation order. Refusing to grant prohibitory order in an appeal under section 96 of the Code of Civil Procedure.
Yes.
That was a decision of the original civil court, which was asserted before the appellate court in the first appeal under section 96 of the Act. That was pending since the other side made construction, an application was filed under Order 39 Rule 1 and 2.
1 and 2.
Read with Order 39 Rule 3 to take up it on ex parte basis. The court advanced the application, but didn't consider it at all. So my submission would be before my lord would be that it is an order of non-consideration. The non-exercise of jurisdiction vested in it. Your lordship may look at the impugned order straight away.
Yes. Annexure?
Annexure at page 35.
35. Okay.
It starts from page 34, annexure 5.
Yes. 39.
12 to
39(1), huh?
12 to 25.
Yes.
The case record is put up today on the strength of advance petition filed by the petition to hear on the urgent petition. Copies of third, the call for petitioner is allowed. A petition. So your lordship may skip the last second para. He also filed an application under Order 39 Rule 3 of CPC supported by an affidavit. Court fixed it to, as such the petition is allowed, put up on 14 to 25 for consideration of the petition. Now the consideration your lordship may look at the impugned order. 14 to 2000, next order. Advocate of filed Hajira. The record is posted today for consideration of petition. On perusal of case record, it appears that RFA, which is of which the present IA is an offshoot, has not yet been admitted, yet hence the present petition will not be maintainable. It's a statutory first appeal. Now I
obviously admitted subsequently. Then what do you want now?
Well, I want that he is constructing a prohibited
Your application be heard.
My lord.
39(1) and 2 should be heard. That's all you. See, the problem is, suppose I'll issue notice in this petition and you are seeking an ex parte order. The service will be affected and then the entire
I quite understand, but this is totally non-consideration.
Can I pass an ex parte order here? You are asking an expert injunction.
I am not asking that relief. Let him consider my application at an early date and no construction in the meantime.
Then it is an expert order again.
Status quo.
Then I am pre-deciding the issue. Your grievance is your 39.12 is not decided by allowing 39.3.
He may grant, he may not grant.
So if I pass that order,
my submission would be
then
for my order.
I am allowing you the 39.3.
He may grant, he may not grant. But this is total
I will only
non-consideration.
say that your application should be decided within 15 days.
I will appear and file an application within a short period. My application for main or the original 39.1 and 2 be decided.
That is there already. Yes. That is there already. He is only
No, he is dismissed. Yeah, application is dismissed.
Will you press? Or the same application will be heard, you tell me.
Hence, the present petition will not be maintainable.
That's right. On the ground of maintainability, he says that I will not hear.
Now, your lordship may direct him to hear it on merit.
Merit. That's right.
And some interim protection. How
can I give interim protection? Then I will have to issue notice. The whole grievance is the court says that I will not pass ex parte. If I will pass ex parte here, what am I doing then?
My submission would be the first appellate court should have. It's a prohibitory order.
So therefore,
it must be considered.
Ideally, the first appellate court done it. I'm with you, but I can't do that. I can't do that.
A litigant will be.
That's right. What to do? This is. Otherwise, I have to issue notice.
At the earliest opportunity.
Either you tell me, I'll direct the first appellate court to decide your application, or I'll issue notice.
What more I shall allow? Your notice cannot solve my problem.
Therefore, I'll direct the first appellate court to decide your application.
Well,
petition.
IA.
Already there. Petitioner is agreed by the order dated 14/2/2025, passed by the learned decision Bhadrak in RFA number 59 in IA number. What is the IA number?
IA number 12 of 25.
IA number 12 of 2025 in arising out of RFA number 59 of 2023. The council, the petitioner moved an application under section order 39 rule 1 CPC seeking some injunction, seeking permanent injunction order, and along with that he moved an application under section under order 39 rule 3 for allowing the application ex parte and pass necessary order. The first appellate court where appellate court. The first appellate court passed the imbue order dated 14/2/2025, which reads as under. Right now, where is the order decree?
Decree is annexed to 2.
You are the plaintiff, huh?
My lord, I am the appellant.
No, you are the plaintiff in this suit.
My lord.
Plaintiff in the suit or defendant in the suit?
I am looking.
Yes.
I am the.
You suffer the degree?
Defendant number 4.
Okay. The petitioner was the defendant number 4 in civil suit number 41 of 2021. Which court is this? Civil Judge Senior Division. There is a Court of Senior Civil Judge Senior Division at Bhadrak has decreed the original suit against which the present petitioner had filed an RFA. The learned trial court RFA, which is RFA being RFA number 59 of 2023. The trial court has rejected the application filed by the petitioner by the imbue order only on the since the RFA has not yet been admitted. So therefore, the application, interim application under order 39 rule 1 and 2 and 3 cannot be entertained. Learned Commissioner with the count for the petitioner submits that the RFA being a past appeal, the RFA filed by the petitioner being a continuation of original proceeding, continuation of original proceeding, the trial court ought to have entertained the interim application, which is of an urgent nature. Therefore, he says the same. I have perused the documents placed before this court and evaluated the submission made by Mr. Mishra at the bar. I am for the considered view that in view of the nature of relief sought by the petitioner, which is which appears to be urgent, the first appellate court ought to have decided the application under Order 39, Rule 1, 2, and 3. 1, 2, and 3. Without admitting into the merits of the present case, I feel it appropriate to direct the DC Bhadrak to decide the application IA number 12 of 2025 as expeditiously as possible. In view thereof, the impugn order is set aside. The IA number 12 of 2025 is restored to its file, and the district judge Bhadrak is directed to the application on its merit in accordance with law within a period of 15 days hence.
Production of the certificate court, the appellate court shall act.
Yes, production of certificate 15 days hence from the date of production of the application. Yes.
Your lordship indicated trial court, that will be appellate court, lower appellate.
Appellate court, I have said appellate court. Yes. I have written this is Judge Bhadrak. That is the appellate court. Yes. Yes. Sorry, one. Yes.
38. May I please have it? The plaintiff in a suit for petition and declaration I present CFT challenging the order dated 6/3/2024.
6/3/24.
Yes.
25.
25.
6/3/25.
6/3/25.
Yes.
That order at Annex 3. By virtue of that order, the land trial court has rejected the petition filed by the petitioner under Order 39, Rule 3, seeking for ex parte ad interim injunction. The ad interim injunction, to the extent that the direction may be given to the opposite parties who are also 1/3 shareholder along with the petitioner, not to create a third party interest. That is the only protections it needs. Because if the land is sold,
only the suit, they are brothers, huh?
yes, yes.
Defendant,
Other and
defendant, you are the plaintiff.
and the plaintiff.
What is the service position? Service is affected.
Service is not sufficient. They have appeared, they have taken time.
Where is the ex parte then? It can be heard.
No.
In a partition suit, if the defendants have already been served, you moved an application thereafter. Why ex parte?
Because my lord, now they are planning to sell another.
So why don't say ex parte? All of them are appearing.
One sale has already been taken out. That I have sought for passing of to set aside that selling. Now, my lord, during pendency of the suit, now they are to sell the rest of the land. So in that case, I will be deprived of.
I understand it.
Yes.
You said that all of them are appearing now in the suit proceeding, where the application has been moved.
Yes.
Then why ex parte? They will be heard.
But they have already taken time for file. They have not filed objection to the IA. IA for interim injunction.
Let us see the impugn order. Let us see the impugn order.
The impugn order lost will get at page 34. The operating person is left in the instance case, considering the fact no such immediate danger is seen to the property. Hence, it appeared that there exists no urgent situation which can lead to an
What is the partition? Yes, you should know.
not to create any third party interest. That is
Let us
that
see.
will be interest of
Then I am allowing the main petition. 39, see, 39.3 is rejected. 39.3 is rejected. So I have to, obviously, ex parte order, the court has not allowed you to this thing. So I have to issue notice and
My contestation is that the law.
And I'm allowing the main petition.
Taken into consideration the situation, emergency situation.
Take out notice because take out notice immediately. Take out notice. Because this is tantamounting to allowing the.
Well, only thing, but it will not affect anybody, man. Neither the opposite party nor the petition anybody, man. Not to create any third party interest, ancestral property. That is the. It is
No, there is a reasoning. There is a reasoning given by the court.
So that reasoning is not. They have not taken into consideration the very intention of the legislature.
So what is the reasoning? Let us see. What is the reasoning?
Reasoning that
court passes a very detailed order.
The details sort of he mentioned, but they have not taken into consideration the very intention of the legislature. So far, Rule 3 is concerned.
Where is the written statement? Show me.
Written statement not filed. At the first instance, I move for the petition. They have appeared. They have neither filed the written statement nor they filed objection to the IA. I for injunction.
No, if it is a self-acquired property of your brothers, I can't
not
stay.
self-acquired.
So therefore, I want to know where in the plaint. Show me the plaint. Show me the plaint. Which property you are talking about?
You lost it on to page 15. The plaint I have.
15, 15 years.
That the
Which plot you are talking about?
It is the property of Chakradhar Prasad Das. Chakradhar means our grandfather. The grandfather of the petitioner. So it's an ancestral property. Actually, the land was acquired by their then that is Ananta, Ishwar and Chakradhar. They acquired the property in 1940. Thereafter, there was partition between the family. Finally, the petitioner, the father of the petitioner got that property. So the petitioner has the right over that property. He is the 1/3 shareholder.
You come to your application, para 27th. Then let the status quo be maintained. Then,
Yes, sir.
Till next date of hearing only. Because then it is tantamounting to allowing your main petition.
No, that is not only valid to protect the share of the petitioner. You want that no third party interest should be created.
Where have you said that the written statement has not been filed?
No, at the first instance, notice has been.
No, in the petition, in this petition, you have said written statement is not filed.
No, that I have not said.
So then that is the whole difficulty.
No written statement filed, no objection also filed because I filed the suit.
Where have you said that?
Appearance. Before their appearance, I filed the CMP has been filed.
Issue notice.
Their appearance was to 26/3/2025.
The present petition is arising out of a partition suit by the petitioner against the opposite party number 2 and 3.
Yes.
1 and 2.
1
and 2. Those were the his brothers. Those were brothers. At the outset, land counsel for the petitioner submits that in the civil suit number 167 for 2025, although the summons have been served upon the opposite party number 2 and 3, have they entered appearance?
In the IA, they have entered appearance.
But no written statement as yet has been filed by them. He moved an application under section 39(3) inter alia, seeking in direction from non-alienation of any portion of the suit length in favor of any third party. He has very categorically averred in para 3 as under para 3 of the application at page 27. He led counsel for the petitioner contends that the suit property is an ancestral property. If the order for if an status quo order is passed, it will not be a prejudicial order for any of the party to the suit. Therefore, the trial. Therefore, he submits that the trial court, by the order dated 6/3/2025, Therefore, the rejection, therefore, the impugn order dated 6/3/2025, whereby the application of the petitioner under section 39(3) CPC, which was rejected, is not tenable under law as well as fact. Issue notice to the party number 2 and 3. What I can do is I will dispose of this petition, saying that let the trial court hear the 39(3) once again by affording opportunity. Till then, the status quo should be maintained. That's a better idea. Unnecessary. Why unnecessary pending?
Yes, yes.
It is a partisan suit.
That's
That's a better idea, right? Hon'Ble. I have carefully gone through the pleadings before the court below, and the also analyze the impugn order. I am of the considered view that in the for the situation and to situation, it would be appropriate if the petitioner is relegated to the court below for moving a fresh application. Under section under order 39 rule 3 and the trial court fresh application under section under order 29 rule 1 and 2, not 3, 1 and 2.
So that is pending.
And so not pending. I am satisfied and file a fresh application 1 and 2 seeking injunction. Ad interim injunction. And the meantime, the parties should maintain status quo insofar as the scheduled property concerned. The trial court is also directed to decide the application express on its own merit by hearing the parties, hearing the parties. Till the application to be moved by the petitioner is decided, the parties are directed to maintain status quo. You maintain status quo, move a fresh application, let it be decided by hearing both the parties. Because it's a partition suit, your brothers only.
Yes, yes.
Yes.
Cut-off time respect with suit property.
Schedule property. Because you have used the expression schedule B. So therefore I'm saying suit property, I don't know how many suit property.
Schedule B property.
Item number 62, 63. At the stand of my lord and friend Mr. Mishra, the matter has been adjourned. He has also informed me for adjournment. But instead of it listed on 21st, your lordship has adjourned 2 weeks after. Interim order is continuing since 2020.
That week will be very tough week. Let it be in the
why I am submitting my lord. Back stay has been filed.
6th May.
6th
May.
No, my lord, 29 or 30.
29, 30, very difficult.
Because the reason being, my lord, getting the interim protection here.
Second. Third is working day. Second. Second for no? Okay. Second for 2 weeks. 3 weeks. Yes.
Second.
So item 15.
Yes.
Lordship. I have served the copy regarding the similar order in the other affair. Item 15. So the case counter case matter.
This is the connected.
Yes, connected. There are 2 affairs.
Koi.
Yes. So in that case, the petitioner is the complainant.
Okay, issue notice. And tag is the serial entry number 1157 of 2025. There is no order. No?
That is a-
Anybody appearing?
No, not so.
Because in that matter, somebody appeared.
We are appearing in the both matter. We are appearing.
Check करो sir. ठीक है? Okay.
Yes, sir.
15. Yes.
16.
Your Lordship, the petition seeking for quash the GR case number 727 by 2023. Corresponding to Kakarpur PS case number 149 by 2023. Pending in the Lowland MFC Nimapada. Your Lordship, my submission is Annexure 1 is page number 12. FIR. My name is not mentioned in the FIR as given by the informant Jahira Begum. Your Lordship, page 12.
Yes.
And also page number 161 statement, page number 30, as given by the Jahira Begum, informant of this case, not mention my name. And so also other witnesses, page number 32.
What do you want now? Who are you? You are.
I am the petitioner.
No, I know, but how are you related to
See, my sister-in-law.
sister-in-law?
Yes, Lordship.
I'll issue notice.
Issue notice.
498A. Issue notice. Yes.
Obliged.
39.
The pleas, Your Lordship.
Yes.
Petition challenge the expiry order under Annexure 2 mail.
Annexure? Annexure?
Annexure 2 mail at page 10 mail.
Yes.
On the ground that the medical officer issued the certificate is a retired and contractual. Not page 10 and 11.
What are you seeking here? Yes. What was the proceeding? What was the suit?
This is a suit for petition matter.
Okay.
With petition is the defendant number 2 matter.
Yes. Yes, tell me what do you want?
The CMA number 6 of 2024 matter.
Where is the plaint? What is the case? I am not able to follow.
Matter?
I am not able to follow. Where is the case? How will I know that who you are plaintiff or defendant, whatever?
I couldn't annex my letter. Can you apply?
Yes.
CSA number 44 of 2010 matter.
You have to tell all these things. 2-page application, you have not said anything. What? How will I head and tail?
Just
Is
for
not,
the- Just for restoration of the experiment.
The impugn notice, I'll issue notice. I'm not able to make out because pleading, there is no pleading, nothing is there. I'll simply issue notice letter. But at least you tell what exactly is the suit, what happened, nothing is written.
In partition, matter is the defendant number 2, my lord.
I have searched everywhere to know whether it is suit for partition, injunction, declaration. I am not able to find out.
Suit for partition.
Anyway, I issue notice, let us. Issue notice, file the requisites, let us. Okay.
Item 40.
Matrimonial dispute. Here the present petitioner or the opposite party.
420.
No.
420.
No, 429. Petitioner has filed an application for declaration of the marriage as void. And wife has filed the application for.
You are seeking quashing of what?
That is.
Annexure 2. Annexure 2.
5.
Annexure 5.
The rejection of the application for amendment.
Rejection for amendment?
Amendment application in a proceeding under section 125.
What is this FIR then?
It is a affair and counter affair between themselves that is spent sub judice in the different courts. Here the crux is only the
Order 6 Rule 17 application is rejected.
617 application.
617, right.
In proceeding under section 12. And the application for amendment has been filed. That has been allowed. Same application has been filed in a proceeding under section 125. That has been rejected by the same court.
Yes.
That is the only crux here. Your Lordship may turn to the proposed amendment at page 34.
34.
34.
Yes, I'm there.
In civil proceeding.
Yes.
Annexure 3.
Yes.
You want to incorporate certain facts which has been rejected. Giving that.
What do you want to incorporate?
That respondent married to another person, she has husband and children before 2011. That has been allowed. This application has been allowed. The same proposed amendment want to incorporate in the written statement of the application under section 125.
125.
125. That has been rejected.
Withdraw and file a fresh one.
Fresh application. No, I have not filed that. I am the husband, my lord.
See, you want to bring
the same fact in
your reply.
In my reply. That has been rejected. But the same Judge Family Court, Baleswar.
I'll an additional affidavit you.
It is unless, my lord, that is when liberty has been granted.
I'll issue notice, family dispute to issue notice, but you can file an additional affidavit.
Unless it is granted by cannot.
Oh, see, 125 what's pleadings 6.
617 is not at all maintainable, but intention of 617 is there.
Stretching too far. You can file an additional affidavit saying that this portion has been allowed to be amended in the divorce proceeding.
That we carried out. Lordship dispose of that liberty, then I can file an additional so cause.
File an affidavit.
Unless, my lord, unless it is permitted.
These are quasi-criminal proceedings.
That is correct.
You moved an application in order 6 Rule 17. Rejected.
One more thing, why I am submitting, my lord, that is unless permission is granted. Because I have also filed an application.
What best thing would be, you move and you withdraw it with, I'll record your statement to file an additional affidavit before the 125 court.
Unless you consider.
I'll say that.
Yes, your lordship give that liberty, then it is suffice all.
Petitioner is agreed by the, where is the order?
My lord, order dated 29/1/2025.
Agreed by the order dated 29/1/2025, passed by the learned family judge Baleswar.
Judge Family Court, Baleswar.
CRP number 99/2019, whereby his application under 6 Rule 17 CRP moved seeking amendment has been done down. The court below has the petitioner. You are the husband, na?
Husband.
The opposite party had initiated a proceeding under section 125 CRPC. In the said proceeding, petitioner is seeking amendment by a short amendment by moving an application under order 6 Rule 17, which has been turned down. The counsel for the submits that the same amendment which was sought by him in the where is that proceeding? 35, na?
Yes, madam.
35 in the divorce proceeding, namely CP number 495 of 2022, has been allowed by the same court, that is the family judge Baleshwar, family judge Baleshwar. However, the impugn order, by way of impugn order, the amendment, exactly the same amendment sought by the petitioner has been rejected in the 125 proceeding initiated by the opposite party. Since the proceeding under section 125 CRPC being a quasi criminal proceeding, strict principle of strict procedure pleading should not be followed. Therefore, the trial court has rightly rejected the application under section under Article 270. However, rejection of the application for amendment shall not preclude the petitioner to move an additional affidavit before the trial court, bringing this back on record. If such fact is brought on record by way of an additional affidavit, the same shall be considered on its own.
Additional
affidavit.
Additional so cause, because the so cause.
Additional affidavit, additional reply. Supplementary reply. Okay. Supplementary reply.
Let us dispose of this.
With this observation. Supplementary reply. Okay. That is better expression. Yes.
41.
There are three matters. In the first matter, I am appearing. Arising out of yes, I have a common judgment.
My learned friend starts.
Okay, let me.
Before 1 minute. Certain देखो 41 and noting the देखो
41.
Your past all the three matters containing the same noting, sir.
Sir, sir. Sir, kindly look to the order dated 1/11/2016. जोड़ा क्या हमें modification पे change.
1/11?
1/11/2016.
Yes.
16 ना? देखिए. 1/11/2016.
In FAO.
In FAO.
Yes.
In a review petition. In the review petition.
Page number?
Page. In fact, the first case. Main court जोटा का record to the culprit someday. जोटा का
31/7/12 this one.
No, that not that. 1/11/2016 order है the notice to be sent to 9A to 9C PLR. That has already been served. And somebody is also appearing in other two connected cases for those.
Which order you are referring to?
Sir, that is more case 1/11/2016. Sir, ticket देखी दो तो review petition में.
What happened?
1/11.
देखी दो order.
There is no order.
No, this is order was factual. Respond number 9 died. So direction was given to substitute. We have substituted. In all these cases, one order is there. 5% filed different of the same order.
Yes.
And it was also published in the newspaper. Order 5/220 publication was there, and the notice has made sufficient by order dated 1/9/2017 in and 18/5/18 in almost all the cases. This is the paper publication. But thereafter, what happened, my lord, maybe some inadvertence, notice was not shown. Again, direction is issued to serve the notice on that particular party. They have been substituted 9A to 9E, and this is paper publication.
But in the first review petition, there is no such order.
No, say order ta hitila. Review petition 264. Sir, gotti order, say gotti lo. It is paper publication. 264 of 12.
264.
Fine.
Okay. Second one.
264 by 12. Same opposite. It is made sufficient.
Independent order dated?
Order dated under 1/9/17. That is 18/5/18.
18/5/18.
Sir, यही order है.
18.
Order number 17, sir.
यही order है, sir.
Order number 17 dated 21/2025.
नहीं, पेपर थ्री। नहीं, सब था, देखो जो order था।
18 says draft publication of the notice against opposite party number 9A to 9E
Yes.
filed late be accepted.
Yes, it was accepted. Thereafter, it was published in the newspaper. That is there. I got the original newspaper.
Draft publication of the notice, so and so, so and so, so and
And
so.
therefore,
In the
the
Odia Daily newspaper, the Samaj. Place for your kind result. Okay. Yes.
that
Says-
is that made sufficient. In other two cases, my lord, 275 and 276,
They appear.
there 1917 order. Notice has been made sufficient.
Yes. So what is the issue now?
Now
So
issue
now
is,
what happens to the notice? Again, my lord, direction.
Let them complete. I do not want to disturb my lord's
Take
proceedings.
notice. That again.
Okay, okay. I understood. Yes, sir.
Yes, sir. Your lordship can see there are 1, 2, 3, 4 independent review petitions. Parties are different. Orders have passed independently in each case. And in order number 17 and order number 18, your lordship have passed an order in order number 18, issue notice to newly added legal heirs of the opposite party number 9. No notice has yet been issued.
You are appealing for whom?
I am for opposite party number. We are appearing for opposite parties, excluding 9 probably.
Excluding all other parties.
Excluding name.
Yes,
9
yes.
were made
The
sufficient.
notice to go opposite party to 9.
Are you appearing for 9?
No, I'm not appearing.
Who is appearing for 9?
Notice has not gone, sir.
No, in one matter, notice has already
sufficient.
At least one matter.
Two matters, sir. 2 matters sufficient.
Yes. In one matter, at least.
275, 276,
Sir,
I have
appear
seen
for
Mr. Ghosh appear for.
Your lordship look to that,
9.
yes, yes.
Mr. Ghosh.
But the record shows that Mr. Ghosh has appeared for those PLRs.
275 or 76?
There is a confusion somewhere.
Just see 264. Who is anybody entered appearance for 9? 9, 8 we.
List का क्या होगा ना? ठीक है, list
तार notice के बेला देखो क्या को.
सर ठीक है, confusion इधर किसी हमारे नहीं सर.
Confusion अच्छी तो अपन नहीं की थी. Already
सर देखो 264, 270. हाँ, हो. ये अच्छा. हम केस का तंगा against yes.
Yes, Ghosh. You
Yes,
file Bakaratma.
yes, yes.
1 minute.
Yes,
See the Bakaratma. Huh?
and this is notification.
Sir, I cannot say to my learned senior friend,
Where is
but
that?
the fact remains, sir, they are not appearing for them. Sir, suppose our case is dismissed as against them, how they are affected?
They are affected. But prejudice to them.
And the prejudice was explained.
We are the petitioner, we will take the responsibility.
That your case is not maintainable here.
दूसरा
Because you have
बात
not
है,
carried
sir,
out orders.
हम केस का मेरिट ऑप्शन की डिस्कस करो.
Merit हवा.
अपन यदि यही will stand on the way of
No, stand. You must have to follow the court's order. That is a judicial order.
से देखिए सर
60. No. That's the opposite part number 3. Huh? 3. Not for 9.
9.
Service is complete, but nobody has entered appearance.
Yes, but
That's the.
but in 1917 order, in 275 and 276, my lord, it has been held that.
But what is the case? Let us understand whether
Yes, sir, yes.
do you have merit on the case or
Yes,
not?
yes, that-
Why unnecessary?
that is
Not that if I dismiss the review, everything goes.
Sir, I understand, sir. Sir, what?
Case is-
One second, Mr. Das. Order number 18, that is a judicial order passed by this honorable court.
That may be inadvertently that order is
No,
passed.
in that, my lord, in that even if a lordship is going to waive this order, then you must have to give some time to prepare because you are under the impression that order has not been complied with. Matter is not ready.
Okay.
Effectively, you are seeking an adjournment.
I am not seeking an adjournment. I beg to draw my lord's attention, sir, your order has not been carried out.
Which order you are talking about?
18, order number 18.
Order number 18.
In 234 of 2012, that is first one. Issue notice to the newly added legal heirs opposite party by the state force. What is that notice?
ठीक है सर, रिव्यू पेटिशन नंबर 275 of 2012 में देखंतु ମାନଙ୍କ ଉପରେ notice sufficient ହୋଇଛି 209/2017 ରେ।
ମୁଁ 234 ରେ ଅଛି।
ଏବଂ all the cases have been tagged together and hard together.
But parties are different.
If my lord allow me only 10 seconds, I will say the brief fact of the case.
No, you tell me miss case number 319 of 13.
Sir.
When was it allowed?
Miss case one.
Who take away, sir?
210 of 13.
Who case?
Order number 17.
First item.
हाँ sir, हाँ.
এটা এই কেস ভর্তি কেস আমি নোটিস
नहीं,
First item.
First item, right?
Yes.
Sir. Upon miss case number 310 of 2013, yes. ସେଇଥିରେ ମୁଁ petition ଟା ଦେଇଛି that to recall to that order. That order has been inadvertently passed.
But this application was allowed at any point?
No, that application is
So
today.
if that application was allowed by order number 18, how 2017 the service is complete? The application was not
No,
allowed.
ହେଲା କି କହିଦଉଛି sir.
other case.
তিনটা case tag together. গোটা ହିଁ substitution to notice gala, notice has been sufficient. ସେଇଟା ହିଁ
One matter, we have to see. 4 individual review petitions are there. Service has to be affected. All the review petitions are in one petition it is complete, doesn't mean that in the other petition.
That is exactly the point, sir. Sir, ଏଥିରେ ଯୋଉ subject matter of dispute ହଉଛି, that is only one issue, nothing else.
But you have filed 3 petitions.
Yeah, that is a mistake. That may
That
permit.
mistake you correct it. If you have filed 3 petitions, in all the 3 petitions, service has to be complete.
Yes.
As simple as that. I can't presume that in one petition it is service is complete. So therefore, I have to presume everything.
3 cases it is
ଯଦି
sufficient.
ତିନିଟା case tag together ହେଲା, common order ହେଲା, common order ରୁ arise କଲା, ଦିଟା case ରେ ସେମାନେ appeal ଗୋଟା case ରେ already କରିଛନ୍ତି ସେଇ
You show me in any petition have they filed Vakalatnama?
ये ସେଇ
I have checked it. None of them.
sir ଟିକେ ଗୋଟାଏ ଦେଖନ୍ତୁ ଟିକେ sir.
Then I'll tell the same lawyer to appear in other matter. Show me who is appearing.
76 and
sir ଦେଖିଲେ 2 sets 275 or 276.
275.
Yes.
yes. One order number 6.
275.
Order number 6. 19/2017 madam.
I'll directly to lease the matter before the registrar to sort it out. I can't waste time.
Good second.
For service, I can't waste. I would dispose of the review petition by this time.
Problem ଏହା ହେବ. Problem ହେବ ଗୋଟେ judicial order ହେଇଛି by the bench. ଯୋଉଟାକୁ ଆମେ file କରିଛୁ petition.
Obviously, see, order 22 rule 4 application is yours. That was never disposed of. I disposed it up. Thereafter, you have to serve as simple as that. In first item, I'm talking about.
ତିନିଟା case.
That application was never allowed. I allowed it.
Sir, ଦେଖନ୍ତୁ
By order number 18. You complied.
That order has been carried out in other 3 cases. How sufficient?
See, in the other case, it is carried out, doesn't mean that the application are automatically allowed.
Automatically କହୁନ sir. Automatically କହୁନ.
It is held to be sufficient. Declare order number 6.
Sir, ଟିକେ ଦେଖିଦିଅ.
Anybody is appearing
1917.
9 matters.
1917 ଟା ଦେଖ
appear କରିଛନ୍ତି sir.
1917 275
ଭକଲାତ୍ମା file ହେଇଛି sir.
Mukalatanaji file each, then we will ask the same lawyer to appear in other matter.
Yes sir.
order number 6 ଟା ପାଇଲେ 1917
We will seek instruction and appear in other matter.
1917 କିନ୍ତୁ
ଆପଣ sir verify କରନ୍ତୁ registry ଦେଖିବ. We are sure sir they have appeared.
1917 କେମିତି ହବ order pass ହେଲା ପରା?
List
ସେଟା ଆଉ ଗୋଟେ
list the matter after 2 weeks. And
ଆଉ ଗୋଟେ case.
I'm listing the matter after 2 weeks. I'll get the record. Yes, get the record. We'll sort it out.
Yes, fine.
We'll sort it out.
हाँ sir.
Yes. देखिए for respondent number 9A to E.
Yes. Proposed
In any
legal
of the 4 matter, any advocate has entered appearance or not?
Yes, ma'am.
You also pass that order.
Yes.
I'll just check it out.
Yes sir. Yes.
Order sheet says my lord notice against topic number 9A to 9E will treated as sufficient. That is the order of my lord.
You have chosen to file 5 petitions. What can I do? You have to serve with all petitions.
That is the only
I'm trying to sort out if anybody is appeared, then I'll
there was one grant. It is the 36 of
then withdraw.
Now what happened?
See, do one thing. Do one thing. Withdraw all the petitions and the petition where service is complete, argue that.
Yes.
Withdraw all the petitions right now. Let us.
Process to sufficient each na.
And then the cases where the service is not complete, withdraw that. And the case where service is complete, argue right now.
ଆପଣ verify କରନ୍ତୁ. ଆପଣ verify କରିଦିଅନ୍ତୁ sir.
Fine cases.
ଯଦି appear କରିଛନ୍ତି
That case that is
Verify kori.
Yes.
Okay. Yes. 42.
42.
Non-appears in the interest of justice. Yes.
43. Lordship 42, I am for the petitioner. Lordship here, filed application for substitution, your Lordship.
Substitution.
Lordship.
Application 155.
1354, 1355 and 1356.
Substitution of 13.
1354, 1355 and 1356.
For the
Substitution, delay condonation and setting aside
the
abatement.
same is allowed. So the legal error of so and so is directed to the court of record, amended being 145. Petitioner to take step to serve the LR.
Okay.
Yes.
My lord, I am appearing for the opposite party number 7. As per my instruction, opposite party number 9 also died. That has to be carried out.
Just see, move application.
I'll take instruction, I'll take steps,
Yes,
your Lordship.
43.
43, your Lordship. Lordship, matter has been admitted. Lordship, however, notice, we have not been able to, Lordship, serve them with a notice. So I request your Lordship, may allow for a substituted notice, your Lordship.
Have you moved application?
Substituted notice? No, your Lordship.
Move application. Let consider the petitioner submits that despite his efforts to serve opposite party number.
No, Lordship, notice was issued, but it is, Lordship, coming back as.
Which respondent is not served? Respondent number?
All the respondents, Lordship. 1A to 1C and.
He could not serve the respondent. Hence, he seeks an adjournment to take fresh steps for serving opposite partners. Matter of
Lordship, fresh steps, Lordship. Actually, we have taken Lordship thrice, actually.
Till then, an application for substituted service, I will allow publication through publication.
Lordship, may keep it to a shorter date. We will file an application.
Yes.
Lordship, interim order to continue. In both the matters, so Lordship. 42 also, Lordship, interim order is there.
Yes. 44.
44.
May I please, Lordship. As per the last order, my lord, requisite has already been filed for the notice to the opposite party number 5, along with extra copy also filed.
Sorry?
Requisite, as per the last order, my lord, requisite are already been filed, my lord, on 5th September 2023. But till, and also 4 extra copy also been filed.
All are 5 CDPO 5 respondent of 5. 5 complete. Respondent of 5 were complete and all other 1 to 4 government.
Yes.
You are appearing for 1 to 4?
Yes.
1 to 4 for respondent of 1 to 4, Mr. Vishwal APS. Service on respondent of 5 is complete, but non-agented appearance so far. Please the matter. In the interest of the yes, after yes.
45.
Mr. Vishwal to file the response to the petition. Yes.
Lordship, 45, number 442 of 2021 for substitution of OP number 9.
OP number 9. IA
442 of 21.
442 of 2021. Allow. Substitution application allowed. The same order for yes.
46.
May I please, your lordship. 46, notice has been issued, but not EID has not been.
Notice sufficient.
Notice.
Please on the respondent number 2 to 3 are sufficient, but non-agented appearance in the interest of please the matter of services. Yes.
I pray you will see one thing. That is, sir has indicated that the certified copy. Last occasion I have already last time I have already mentioned before lordship. The certified copy which has been
solve it. No,
that may be ignored.
Let them come. We'll hear it. Yes.
47.
First order is under Annexure 6, my lord. The second round litigation. The status of the opposite party wife is also challenged. Wife has filed an application under section 125 that has been allowed on ex parte and filed the execution case. In execution case, my lord, warrant of arrest has been issued and the amount has been recovered. more than 20 lakhs. Subsequently, by the intervention of the order of this Hon'Ble Court, my lord, it has been restored to the original condition. I file an application when the status is in dispute and he has received more than 20 lakhs towards interim maintenance. The said amount be.
I'll issue note.
Yes.
Issue note. Yes. You seeking recovery of that money?
No.
Then
Return that money or to deposit the same before the court. Your lordship knows better. But short date I am not paying for stay of the proceeding. Also not filed here. I am cooperating. Short date it will be decided. The Bhubaneswar matter.
Yes.
48.
Lord, Mr. Milan Khan, senior advocate, will argue the matter in this case. Next week.
My lordship, I am here for the part 2 of the 48, my lordship, for the interim bail, my lordship.
Interim bail.
Yes, my lordship.
Why this matter has come to me?
4 months back, it was rejected, your lordship. Honorable Justice. In this matter, my lordship, one of the co-accused already bail because the mother of the petitioner is on the nearly deathbed, my lordship. That is there. And the medical documents are there, my
Which
lordship.
application? IA number? Interim bail application number?
The petition number is basically, that's a main petition is.
No, IA. Yes.
Yes, my lordship. IA number is 437 by 2020.
437.
437 by 2000.
Second matter? In the second matter you're talking about?
Yes, my lordship, second matter.
437. Notice has been issued in this 437.
This matter, like a co-accused already, my lordship, has he also been granted the interim bail, my lordship. I'm just putting it on the record.
No, medical ground you are seeking, it can't be, parity.
Your lordship, a fixed date, we can hear the matter merits, your lordships.
My
lordship, I'm
issuing notice, he has to verify the medical record.
Okay, my lordship.
If you notice.
Apart from that, your lordship, two things I want to mention, your lordship.
I am only issuing notice, verify interim order. I am not passing any order.
My lordship, interim order. My lordship, I would like to 10 years, my lordship, 10 years in the custody trial.
Is it necessary to waste time? I am issuing notice.
Your lordships, on same grounds, your lordships, he had filed interim application twice on the same grounds and it was rejected by the.
All right, you say that.
Yes.
A regular court will hear it. I am just issuing notice to verify the medical which he has filed in the application for interim prep. 437 of 2025. Issue notice. Mr. Naik accept notice. And the application is for interim bail on the ground that the mother of the petitioner is terminally ill. Least the matter after 1 week. So,
Your lordships, I want to file a reply. Possible date, my lordship. Because my lordship, only I will take 30 seconds, my lordship here.
Do you dismissal?
No, my lordship.
I'm issuing without verification, I'll allow. And this matter has come to me because the regular court is not sitting. I'm just issuing notice. This is an interim application. His mother's health is
Yes, my lordship.
She is suffering. They have to verify.
Your lordship, one small request. Even if the mother is unwell also, why the bail should not be granted, your lordship, I want to file a reply.
Yes. You definitely file.
Yes. And your lordships, lordship, give a fixed date.
I give it a fixed date. Because he has to check it up when the court is sitting.
Yes.
The regular court is sitting.
Regular court, your lordships?
Yeah, regular court. Yes. Yes. 49. Yes. How this matter has come? Mention it.
My lord, the petition is costly since 12. The petition is costly since 12/3/2025, my lord. For the alleged offence under section 66E and 67 of IT Act.
Yes.
As per the application.
What are you checking here? Interim bail.
Interim bail, my lord.
Interim bail for each marriage. The marriage has been
Fixed to 18/4/2024, my lord.
18?
18/4.
18/4/2025.
Verify.
Yes.
I'll fix it on 15.
We have very.
My lord, I am not the principal accused, my lord. I am the co-accused. Against me, my lord, allegation is that, my lord, I have.
Are you arguing on merits or arguing on for the interim? Merits, then you have to argue there.
Interim.
Interim bill. Concentrate on interim bill. Whose marriage is this? Verified, huh?
Annexure 3, page 16, my lord.
Yes. Who is Rajesh Mishra?
He is the co-accused, my lord. Principal accused is Sumit Kumar Mahapatra.
Whose application is this?
Rajesh Mishra, the present petition.
Your marriage is fixed.
Mine.
19. Verified.
Yes. Your lordship kindly see the allegation.
What are the allegations?
Allegation.
Page
10.
Mine.
Yes. Yes.
ଆଜି 9/3/2025 ମିନିଟ୍ରେ ମୋର ମାଉସୀ ପୁଅ ରାଜେଶ ମିଶ୍ରଙ୍କ ନମ୍ବରରୁ ଆମ ଫ୍ୟାମିଲି ଗ୍ରୁପରେ ମୋର ଓ ମାମୁଁ ପୁଅ ସହ ଥିବା ଗୁଡ଼ିକ ଛାଡ଼ିଥିଲା। ତେଣୁ ମୋର ଅନୁରୋଧ ମୋର ମାମୁଁ ପୁଅ ସୁମିତ କୁମାର ପ୍ରିନ୍ସିପାଲ ଯିଏକି ମୋର ନିଶାଗ୍ରସ୍ତ ଅବସ୍ଥାରେ ବିନା ସମ୍ମତିରେ ଶାରୀରିକ ସମ୍ପର୍କ
Key, flag key. Yes. Yes. Okay. When the order was passed, number 9/1/2000. এই কেসে না ও করছে Yeah, what is the status of criminal CRLMC number 25 or 20 for 2016? Just check that. Is it 2520? This is the matter, huh? Okay. Is there any stay here? Is there any stay? There is no stay here. There. Right on. The matter is listed today pursuant to a letter dated 20/3/2025. Issued by a third additional sessions judge Barampur to the deputy registrar judicial of this court. it appears that while using up the BLAPL number 19686 of 2012, this court, by order dated 9/1/2013, directed the trial court to complete the trial of ST case number 11 of 2010, arising out of BNpur PS case number 61 of 2009, within a period of 2 months. 2 months. The subsequently thereto, a criminal revision petition. The prosecution preferred a criminal revision petition 359 of 2013, challenging some interim order. While the order dated 5/9/2013, challenging the order dated 5/9/2013, passed in this case number 565 of 2013, arising. Challenging for against some interim order. The said revision petition has been converted to criminal MC number 25/204/2016. Interim order. An interim order dated 9/5/2013 is operating in the had been passed in the revision petition, which is in operation till today. That's the reason the trial court is not able to conclude the trial as per the direction of the direction dated 9/1/2013 in BLAPL number 19686 of 2012. Intimating this fact, the third additional session has addressed the letter. Regarding head to the contents of the letters, it would be expedient to list the criminal, list the present matter. What is this present matter being CRLMC number 25/204/2016 for final disposal on the 30th. Okay, Trish. Okay. Yes.
51. May I please, Your Lordship, I am appearing from BC Barampur Ganjam.
Yes.
CRMC 3448.
Huh?
Judgment here.
You have not filed the requisites.
Your Lordship, 26
Pursuant to the order dated 3/3/2025, the petitioner has not filed the requisites within time. Hence, party number 2 is not complete. Let the petitioner take fresh steps to serve opposite party number 2. This is the matter of yes. Next.
Lordship.
Sir, you have not filed requisites. File requisites so that service can be completed.
Lordship, এটা judgment ହେଇଯାଇଛି 26 ମାର୍ଚ୍ଚ ରେ. 26 ମାର୍ଚ୍ଚ ରେ judgment ହେଇଯାଇଛି এটা.
52 ଥିଲା ନା ଏଟା? 51. So what do you want? You want to withdraw?
Yes, Lordship.
Right now. Then counsel for the petitioner 51. Both the matters?
Yes, dear Lordship.
Petitioner.
Item 52, Lord. 51.
Counsel for the petitioner submits that the matter has become infructuous as the trial court has already pronounced the judgment.
Both were acquitted, Lordship, on 26th March 25,
26 March 25.
26 March 25. 26 March 3448.
Hence, hence this petition infructuous. Accordingly, the same is disposed of. Yes. Both the matters disposed of. Yes.
52.
May I please, Lordship, my lord. My lord, is a case, my lord. The shop was unlocked by the opposite parties, my lord, and they are not allowing, not allowing to take back my jewelry, my lord. Even much less that I am operating, So my learned friend is appearing for the opposite party. 2 and 3, yes. 2 and 3, other the OP1 refuse.
What are you seeking in this petition?
Seeking to quash the order which has torn down the conditional order of the first court. May I invite Lordship, yes, sub-collector. It's 18, my lord.
18, huh?
1-8.
Yes.
1-8, the last paragraph.
Yeah.
In view of the, may I read, my lord?
Mm-hmm.
In view of the aforesaid position, the criminal miscase is allowed. The Tahsildar Kendrapada is directed to unlock rooms of the petitioner's jewelry shop. The IIC Kendrapada is directed to provide necessary police assistance and when
required.
This is my direction.
Yes.
This was turned down by the revisional court.
This order was passed in which proceeding?
In a 133 proceeding. In 130 conditional unlock. Now, Millard, I am not also interested to run my shop only to the extent that the jewelry which is.
What do you say?
No, I have no objection.
Then
yes,
go do it.
Yes, you know, that is
He doesn't have an objection. Why do you need it?
No, they have objected. They have objected.
He says no opinion.
But now, you last after this. Yes.
No. Come on
yes.
16th. Come on 16th.
Come your lordship.
Go and open it.
Yes, sir. Yes.
Comment on 16th and tell that
yes.
petition has become infracted. Okay.
Your lordship has some.
Will not pass the order.
Your lordship may object that again they will create hindrance.
That is reason I'm keep
number 1 is creating.
Okay, then number 1.
Who is opinion?
Who refused the notice? Both are the sister Miller.
I'm coming.
Mother has no mother.
Refuse. So your lordship said that
quash कर दूं
मैं quash नहीं
serve the opposite party number 1 through the which police station is this? IIC
Kendrapada.
IIC Kendrapada town, huh?
Yes, that will.
You supply a copy.
Yes,
extra copy to supply.
Like
please on 30th.
Diploma that will service.
Service through IIC.
Yes, I'm immediately giving.
Yes.
54
may be notes. The petition is challenging the order of the court below, my lord. The vehicle was seized by the IO. My lord, may kindly have a glance to the. My lord.
Notice, sir. You have not taken this step.
My lord, notice was issued to the opposite party number 2162/2025, my lord. On the address, my lord, may kindly have a glance to Annexure 1, page 12, my lord.
Oh, yes.
A hypothecation loan cum agreement was made between the petitioner, who is the financial company, my lord, and the opposite party number 2, who is the registered owner, my lord. Page 12, my lord, may kindly.
I understand what you want to show me.
That, my lord, the OP number 2 has given that address, my lord. In that address, we have.
I can't search him. Either you file the fresh address or take
say address
in
what can I do?
Unless the service is completed, there is a judicial order to that effect.
But se absconder roses. Interesting fact, my lord. I said a more vehicle in my lord. May kindly have a glance to page 22, my lord. May kindly have a glance to page 22, my lord.
Opposite party number 2 be served through IIC which police station? West Bengal address. West Bengal address.
My lord. Well, interesting fact is, my lord.
First serve, then we'll see the interesting fact.
My lord, more vehicle number
there is a judicial order to serve opposite party number 2. Unless that judicial order is reverse, I can't help you. It has to be complied. Take fresh steps. It doesn't happen, then move an application to dropping.
Seizure gote number ଦେଇଛନ୍ତି କିନ୍ତୁ ଚାର୍ଜ ସିଟ୍ ରେ ଆଉ ଗୋଟେ number ଦେଲି.
What can I do? You tell me. Then it also for the petitioner to take first step for serving opposite party number 2. let him do so within a week, at least take a step or move an application.
Local police station.
I can't give a direction to the Calcutta police.
Say address to this are already potential.
Calcutta police. He is appearing in the case before trial court.
No.
Is he appearing?
He's absconding.
Have you issued NBW anything of the sort? Just check it up and tell me. Check it up.
So,
yes.
55.
Item 55, Lordship, we are taking fresh steps to issue notice to opposite party, Lordship. The notice issue was returned unserved. We'll take fresh steps.
Okay, let it come for the petitioner.
We'll file the correct address.
Fresh steps to serve opposite party number 2. Let him do so. Let her do so within a week and release the matter. Yes.
56.
Yes.
Well, I'm appearing for the opposite partner 6.
Yes.
Last occasion, I intimated your lordship that my opposite partner 5 in the jail custody at Hon'Ble jail. That is why my lordship had directed the counsel upon the petitioner to take steps to serve notice on him.
Yes.
Opposite partner number 5, as per instruction, he is in jail custody. Am I correct?
Yes. That's right.
He is in jail custody.
Last time, my lord, I also. Hon'Ble jail.
Hon'Ble jail. So, I suggest one thing. My friend is not representing him, and I also not going to represent unless until there is an instruction. Your lordship, I am submitting one set of copy of the petition. The IIC be directed to solve it in the jail.
You send it to the superintendent Hon'Ble jail. Name is there.
What steps were taken as per the order passed by the Hon'Ble court?
Who is he? 5.
My lord, the husband of the opposite partner 6, my lord.
Akhil Prasad. Send a copy to the superintendent Hon'Ble jail.
As you director, I have no objection.
Send a
I will
copy.
I will instruct to send a copy to the superintendent for service.
Yes. The respondent number, opposite party number 5 stated to be in the jail custody and lodged in Hon'Ble jail. Therefore, the service on him could not be effective. She, Mr. Mahapatra and counsel, senior counsel appearing for the state, appearing for the petitioner submits that he would send a copy of the petition to the jail superintendent through him. Opposite party number 5 could be served. Let him take necessary steps in that regard. Leave the matter after 1 week. After 1 week, I'm discussing. You use. He'll give a date.
Within 3 days, I will comply the order, and your lordship may fix a date because this is matter.
No, date has to be fixed because the respondent number 5 has to know that particular date. Fix a date. Fix a date, and the counsel for the petitioners shall also enclose the proceeding, the downloaded copy of the proceeding of this court along with the petition. All the proceeding also you send along with the petition.
57.
Yes, there is a report is at flag C by the mediation
And that apart, my lord, the notice issued to.
Successful or not?
The sitting was going on, my lord.
Okay.
And for that, we need some time, as because the
Mediation process is still going on. Lease the matter after 2 weeks.
and interim order is to
Interim order to continue.
So far as, my lord, in this case, I am appearing for the OP number 2. And so far as the.
He is the complainant and
OP number
petitioner
2.
in the lower.
Mediation is going on.
Yes,
Mediation report is saying that report has sent that noting of the cause list.
One report is
and
part C. The lordship, as because the opposite party number 3, notice on opposite party number 3 is unserved. Your lordship may direct the IIC to serve that notice and the no.
Earlier, my lord's direction, the notice was gone 2 ways. One is by registered post with AD and another one through the IIC, local IIC. And let the report may be.
The IIC is attempting to serve. Let us see. Yes. Please it. Yes.
And the state may be directed to collect the report from the.
Mediation process is going on. All these things you tell the mediator.
Mediation.
Yes, next.
May I pray, let it become 3 weeks after my lord.
3 weeks.
Deeply. Interim order to continue.
Yes.
59.
My lord, this is an application for amendment of my petition, CRLMC petition. Inadvertently in paragraph 3, I have perused a incorrect FIR and attached the same. My lord, I have filed the certified copy of that FIR, correct FIR. The written report was.
But C is correct. Why don't you withdraw it and file it?
The matter is posted to 15th. It will be 15th in the trial court. The matter is posted to the 15th. That will be.
Which is the IA?
IA, my lord, 989 of 2025.
What correction you want?
My lord, in paragraph 3, I have.
Paragraph 3 of your petition.
My lord.
For the reasons stated in the application, the same is allowed. Paragraph 3 of the petition stands replaced by the schedule amendment attached to application. Petitioner is directed to file a consolidated petition. Please the matter.
My lord, consolidated petition will be filed in course of a day. My lord, my direct next week, my lord, it is.
Please it.
Available.
Yes.
60.
May I please, Lordship? Lordship, there's 2 IAFs that has been filed, 312 and 313 for substitution and condonation of delay. The sole appeal.
How much delay?
Lordship?
Delay, how much?
Lordship, the sole appellant died on 7/11/2024 and we have filed this on
Delay
27/1/2025.
delay. SR report. You have not calculated delay.
No, Lordship.
Well, issue notice on application, both the applications. Yes. I'm issuing notice on both the applications. Yes.
61.
I'm for the petitioner matters.
Yes.
The CMP arises out of allowing a 3912 application.
Sorry?
Order 39 Rule 120 application, where injunction has been granted against me. I'm the defendant, the opposite party is the plaintiff. Now kindly come to annex the plaint.
Where is that injunction order? Let us see. Which you are impugning here.
57, my lords.
50?
57.
Yes. What was the suit?
Suit for injunction to restrain me from entering the house.
Okay. You just see your impugn order. Nobody can read.
The certified copy.
Can you read it?
Well, I have got a better copy. I think maybe because of scanning, it has been
Horrible. Nothing can be. Nobody can make out anything about it.
Your Lordship will
Can
take
you
up
file
the
it?
physical file.
Can you file it in type copy?
Yes, no, I can give this.
The physical file is
very
available.
much.
Physical file
That
will
is-
be better.
That will be better, my lord.
File the physical file.
Physical copy is there.
There.
The scanning may be that it has become lighter.
Scanning. Yes, tell me what is the case? Is pending since?
Since 21, Miller.
21.
Yes. What is the state of the proceeding now?
Now, so the hearing has not yet been commenced, Miller.
Is there any stay? No.
No, the status quo has been granted by this honorable.
Now, there are two orders. One by the SDGM Jagatsinghpur in the DV proceeding, and where the order has been passed for share household.
Yes.
Now, I have produced that order before the trial court. Trial court refuses to recognize that order and says that that order is not binding on me, and says that injunction and restrains me from entering the house. So both the orders are in conflict with each other. Now, that order has been passed earlier in a separate special statute. Now, my first submission is,
what was the suit, first of all?
Can I come take your lordship to the plaint?
Page 10.
Page 14.
Yes. Suit for declaration. What is it?
Page 17 is the prayer.
17 is the prayer.
Yeah.
Page 17. Let decree of permanent injunction be passed against the and her agents from disturbing in the peaceful continuous exclusive possession over the suit land and dwelling house standing over it in any manner, from disposing plaintiff and her husband from the suit land and suit house and cost.
Yes.
So basically, to give not effect to the DV matter order, this suit has been filed and injunction has been granted against me, restraining me from entering the house. Now, the order in the DV case, kindly come to the order.
Yes. There is a conflict now.
There is a conflict now. The question is that once there is an order by a competent court under a special statute, can the civil court restrain me from not implementing that order?
Have you filed 31 proceeding?
My lords?
31 proceeding, have you filed?
I have filed that application under section 12. Kindly come to.
You got an order there.
Yes.
You got an order. Then file a 31.
Now there is a restraint by the civil court.
You file it. Let us see what 31 court says.
No,
whether this affects him or not.
Now, kindly appreciate one thing. Kindly see that order at page 46, 54.
12 order.
12 order.
Yes, where is that?
54.
54. Yes. Yes.
So kindly see the first page. I am the agreed person and respondent number 2 is the plaintiff.
Yes.
So kindly come to the ordering portion at page 56.
Operating part is page 56. Yes.
The petitioner be protected from any kind of disturbance in her staying in the shared household. If she is already
Same
staying-
household. Same household.
Yes.
Share household.
Shared household.
Share household.
Shared
But
household.
same.
No,
Yes.
no, not same. That is a
Same
disputing
property.
statute.
Now, what to
Let him complete.
Let us see.
Let him complete.
Let us find out now. Let us
He
see.
is already staying there.
Let us see the suit now. Let us see.
Miller,
The matrimonial house of the petition situated at Harta number 208, lot number 376 by 504.
Show me the plaint.
Land page 18, Miller. Schedule property or lots.
Page 18, huh? Yes.
Page 18.
Yes.
Khata number 45.
Khata number 45, plot number 376, 432.
45, 376, 432.
Yes.
Now your lordship may come to page 56, the order. DB order.
Khata number 208.
Plot number 376 by 504.
Yes.
Different plot.
So that is the dispute they brought out that this is not the same house. Now my submission to that is the order passed in the 12 application is under the Hull plot number.
What they have given in the suit.
In your petition, where have you explained this position?
No, that dispute only
In
came
this
up.
petition, today's petition just showed. Tell me, where have you explained? These two properties are different, are same. Where have you said that? In your pleading. Where have you said that the plots and this thing are same?
Kindly come to page 6 of my petition.
Para 6.
Para 6. In order to controvert the allegations of plaintiff, the defendant filed a written statement counterly as well as.
Have you filed counter, sir, to this?
No counter.
No counter.
You answer it.
Miller,
The problem is the problem today is there is an injunction order.
Yes.
Which is operating against her.
Yes.
And there is an order in her favor. Even if we file 31 proceeding.
Miller.
Because of this suit proceeding,
Miller.
you can't execute it.
No. That the answer is no. Your Lordship may kindly see the impugned order.
Yes.
That the order passed by the Law and District Judge.
Yes.
Your Lordship may kindly turn to. It starts from.
Yes. 67.
Annexure 8.
67.
Page 67. Your Lordship may come to page paragraph 15, page 85.
85. Okay.
Paragraph 15, Miller.
Yeah.
Paragraph 15, 17, the appellate court clarified it, that it is in respect of a different law. On perusal of the plaint of the respondent plaintiff Anupama Singh, and as well as I filed by her bearing number 32 of 21, it appears that the petitioner Anupama Singh has sought for temporary injunction against opposite party Mita Samak in respect of the building situated over plot number 376 by 432 33 decimal under Khata number 45 in Mauja so and so. Lordship got it, Miller.
Yes.
Then your Lordship may kindly turn to paragraph 17.
Okay.
Before that, para 16 last 3 lines, Miller.
It says that it's a different property.
It is a different property, and your Lordship may kindly mark the language of the.
Then why don't
Question is about plotting text now.
No, not
That was the order.
No, question is you are now apprehensive. Why don't you file section 31 application?
Yes. Miller,
if that court says,
I have got
that it is a property, then you can read it out.
Miller, another.
That's Abhik Pata as well as the Hal.
Miller,
File it with an affidavit.
Miller, another thing, Miller.
So correlate
Yeah,
that is the same property. It is what they have done in the plane is give the Savik plot number. Now what he
Deviate.
Miller, one thing your Lordship may she was claiming to my daughter-in-law. Miller, her marriage has been severed by a decree of divorce confirmed by this Honorable Court.
Right, that is not an issue here.
No, that is the issue, Miller. The right to.
No, I am testing the injunction order.
Yes, your Lordship may kindly see the injunction order.
The DB order was 45, huh?
DB order, your Lordship may kindly see. Page 56, Miller order.
Yes.
If she is.
What was this order?
Your Lordship may kindly see the operating part, page 56.
Residential order.
Your Lordship got it.
Yes, I got it.
The Khata number, plot number has been mentioned, but the word, your Lordship, the petitioner be protected from any kind of disturbance in her in the shared household if she is already staying over Khata number so and so, plot number so and so. My injunction is in respect of a different property. If she gets a protection order from plot number A, can he enforce it in respect of plot number B? For plot number, the other plot, I have filed the suit for injunction.
You filed the affidavit. And you
that he is disputing all these documents.
but still I am at loss to understand why have you not filed section 31?
That instruction I don't have. My instruction influences.
You have got a protection order. See, listen, you have got a protection.
My lord.
Protection order relating to a party X property.
Yes.
1 minute, X property. According to you, as against that X property, there is an injunction order operating against me. So therefore, the protection order cannot be executed. That's what you are saying. But what the court order says, it's not an property. It is in fact void. If that is the case, then why don't you resort to 31?
In my objection to the IA, I have given that this plot number with the scheduled property of the claim is a subject plot, and this same property in hall number is different.
That
So
the
that inquiry was
that
not done.
that will be decided in the suit.
That cannot be decided because another bar is section 41A is a bar, the specifically fact of granting an injunction. But there is an order already. So question of granting injunction does not arise. Restraining me.
So that is a different ground that we will examine. But your first ground, that what for this injunction order, even if I got a protection order under section 12, I cannot get the benefit of that because this is hurting me.
Conflict.
That's your first ground. If that first ground is not tested anywhere, that could only be tested in section 31 petition.
Right.
So section 31 cannot be because there is an
Why can't we? Just read 31.
Unless the CMP is decided on merits that this the courts below, trial court as well as the appellate court, has erred in not taking into consideration the order of the DV court, because the trial court says that there is no DV order.
No, the trial court says that DV order is operating in different property altogether. That is, he has read out page 85, 87, 80. No, I read it.
Kindly see.
That could be only tested in 31 probably.
Kindly come to page 63.
That could only be tested in, I am telling you, that could be only tested. I am not going to test that.
What the trial court says.
I can't go by a presumption that it operates. If 31 court says that it is the same property, then you come here, I'll set aside. Straight away, I'll set aside.
Section 31, if I file a section 31, it has a separate jurisdiction altogether.
12 order is there with you?
12 order is there.
How will you
Now,
get it
39 order is also there.
12 order is there. How will you get it executed? What is the procedure?
I am still saying.
31 is the procedure.
Status quo is there. Order is down by the restraint order. They are trying to throw me out.
Then the other ground will see. You filed and the.
I filed.
That was the order, your lordship. Kindly say your lordship's last order. Despite your lordship's order granting him more than 1 year, the index has not been filed. Your lordship kindly see the order, previous order, your lordship.
How many prejudice?
Despite the order of injunction, I am unable to come to my house. 8, 9, 22, kindly see 23. 8, 9, 23 order, your lordship kindly see. Specifically, your lordship's directed.
Yeah, plot index and all.
Yes, till that it has not been filed for 2 years.
It's ready with me. What format is wrong? There's a new change.
Let it be filed before your lordship peruse it today.
Order dated 8/9/2023. The petitioner has not filed the plot index as directed by the court, and by therefore last and final opportunity, 1 week time is sought by Mr. Paul. Same is granted. Let me file within 1 week. It's made clear that if plot index and the other necessary document to substantiate his case is not filed, then the right to file those documents shall be forfeited, and the matter will be heard as per the on the basis of the material available on the court. Okay. Please
give a copy to him.
Give it. Yes, please.
Interim to his. Interim or test.
Yes, interim. But still you have to, file 31.
Yes. Your lordship calling it.
He'll give a date.
May I pray for a very short date?
Short date one.
Lord. In item number 64, my lord, the pit. Lord, in item number 64, the petitioner before your lordship is the plaintiff, before the learned trial court.
Yes.
A suit is filed, and if your lordship will look at the prayer, it's at page 37. There were 3 prayers.
Yes.
One is 1/8 share to declare the sale deed as illegal and void.
What was the suit?
Well, this was a suit in respect of a property where a claim was made on the basis that the property is a joint family property, and I to the genealogy, the lineage, which has been
suit.
sorry,
It is a partition suit.
partition.
Yes.
And there were 3 prayers, major prayers. One is to 1/8 share. The second was to declare the sale deed as void. And the third one is to restrain permanently. Along with the suit, there was an application for under Order 39, Rule 1 and 2. The trial court grants an injunction. The lower appellate court vacates the injunction order and makes observations which are completely prejudicial to my suit which is pending.
Where is it?
If your lordship will look at that order, that is at page 20.
Yes.
It starts at page 20. And if your lordship
How
will
are
look
you
at
related with the respondent?
what?
How are you related with the respondent?
My lord, I'm not related. One of the co-sharers has sold the property to the respondent, though it is a joint family property which has been noticed by the learned trial court in its order. I'll show that order to your lordship. That was noticed by the trial court, but the learned the learned lower appellate court does not notice that at all. It goes on the basis of a consolidation proceeding.
But then you being the plaintiff is alien to the family.
No, my lord. I'm one of the family members. If your lordship will look at the genealogy, which is at page 4.
Yeah.
The original land belonged to Gokhei Naik. That is the 1930 ROR.
Yes.
Your lordship has.
You are descendant of what? Lakshmidhar Naik.
I am Lakshmidhar Naik's daughter. That is number 4, Sasmita.
Sasmita, yes. Sasmita. You are Sasmita Swine.
Yes.
Okay. Yes. Come to that order now.
Now, if your lordship will look
Appellate
at,
court order.
sorry?
Appellate court order.
Yes, my lord. That starts at page 20. And if your lordship will look at page 21, paragraph 2.
Yes.
The learned lower appellate court notices that my prayer in the suit is for 1/8 share.
Yes.
At para 2.
Yes.
And then at para 22, it also says that I have broken my relationship because of my marriage. And I was outside the family for a long time. And then if your lordship will look at page 25, para 5. Now, this is where the learned lower appellate court completely deviates from my prayer.
Yes. During the course of argument.
During the course of argument, the learned counsel on behalf of the appellant has submitted. Appellant is the other side because I was holding a.
Yes.
That the suit land stands recorded in the name of the defendant number 2 in consolidation ROR and sold by him to opposite wide RST number so-and-so. The OP has mutated the suit land in her name after purchase and is paying rent since long. The defendant number 3 of this case has instituted a suit so-and-so, Kujang, for self-same relief, wherein the present plaintiff is arrayed as defendant number 5. I was never issued notice because the address given in this suit, apparently, because I'm not in possession of this, was of my paternal. By then I was married.
Yes, proceed further.
But without disclosing about the previous instituted suit, the plaintiff has filed this suit with IA, which amounts to suppression of facts. Now, if your lordship will straight away go to page 29.
Yes.
And here the learned lower appellate court discusses about the consolidation ROR, which was never a subject matter of challenge. It was only with regard to my 1/8 share, whether I'm entitled or not.
Yes.
Deals with it, and if your lordship will leave about 4 or 5 lines from the top and read, till then it has to be presumed that defendant number 2 has valid right, title, interest in respect of the suit land.
Yes. Are you appearing?
Yes.
See, in the interim stage only the all findings comes. What left in the suit?
If I may please, my lord.
Yes.
My lord, my learned senior has said that it was.
And he virtually gives a declaration.
My
While
lord,
deciding 39 want to give a declaration, he has a right, title, interest and everything, then what remains?
if I may please, my.
Yes.
My lord, my learned senior says that it was a suit for partition. First of all, it was a suit for declaration of her 1/8 share on the basis.
That's a more of a reason that in a declaratory suit,
My lord,
you should not give this kind of finding in the interlocutory stage.
My lord,
Partition suit is better off because everybody is a plaintiff there.
My lord, why the learned district judge has said this? Because the sale deed, which my learned senior in the suit has been challenged, arises out of the consultation settlement. My lord, the plaintiff and the name of the person whose name is in the consultation paper are related. He is the father of the plaintiff. After that consultation, my lord, consultation.
On the, do you say that this declaration, which is made in page 29, is on the basis of consolidated authority order?
Yes, my lord.
And then how can this declaration can be given?
My lord, because
he has a very title, interest in respect of the suit land and transferable right. Everything.
My lord, consolidation authority has the power to adjudicate the right title interest
File
of the
reply, listen note. File reply.
My lord.
Listen notice, so accept notice.
My lord, the notice has been issued.
Notice has been.
And an interim order was passed. But when this matter came up on I'll just tell your lordships on
23. Yes.
My lord, when this matter came up on 5th of April 2024, I was a little in personal difficulty. So I sought for an adjournment, not me, but my colleague had sought for an adjournment. And they had moved an application for vacating that interim order. That application was taken up and the interim order was vacated. If your lordship will look at that order, that is a 5/4/2000.
When the interim order was passed, how can
My lord, there is. My lord, the consultation authority has the power to adjudicate the right title interest. My lord, the same order, the same consultation order was never challenged by the plaintiff.
That about the
My lord,
there is an interim order passed on 21/3/2023. It is vacated in subsequently.
My lord, the interim order was vacated and now it is for final hearing. My lord.
For final, it will take little time. Right up. Vacated by the interim order dated 21/3/2023, which was then vacated on 5/4/2024. It's restored. These the matter for final disposal on a particular date. Give a particular date. It is made clear that no further adjournment shall be
Could your lordship
either of the party on the text whatsoever. Yes. Prepare and come with written note. Yes.
Could your lordships have it on 21st of? Or if it's too early, I leave it to your lordships.
First week, may you choose between 5 to 9. That is the only week which is little relaxed.
Lord, we can we have it on the 9th of
9th?
Very grateful.
Prepare short note and come and finish.
Very well.
Yes.
Very well.
Yes.
Very great.
Next. But who are the senior counsels are here? Senior counsels are there. कितना मतलब चाहिए? Follow up notice matter. The after notice matters are from 65 onwards. All after notice matter. Right? There is a special matter also fixed. Senior most first. Senior most first.
Sorry.
Yes. I have got a matrimonial, in fact, two matters. One against the vigilance and another against the Indian.
Item number, sir?
What?
Item numbers?
83.
83.
So in both the cases, Lords, but I have made an interim application in both the cases.
Yes.
The problem is that my industry has been attacked.
You tell me a particular date of your choice.
Next week, any date.
Next week may not be possible. That 3 days. Thereafter, you tell me.
All right. If that is convenient, but I cannot.
No, you just, because you have been waiting, give, how much time will you take your?
Only this.
No, 4 weeks. See, this was, notice was issued long back.
Your lordship, if your lordship feels that they need to reply to
The notice has already been issued, na? Then you file it. I'm giving you time, file it. File it.
In case we have to file it back. But main case is concerned, we have to file it back. So when I is concerned.
Who stops you file reply in IA also? Who stops you file? Since I'm not taking up the matter, now you have this opening for 1 week, whatever. I'll put it on second of.
1,200 persons are out of employment.
So therefore, I'm taking it up on second.
State is also losing 300 crores of revenue.
Yeah, state is happy to lose it. That's what the state is opposing you. State is happy to lose the revenue. What?
Nobody is happy. I am not happy. They are not happy.
Let it be on the second then. Second, 20? No, 2nd May I'm talking about.
22nd or 23rd in the
23rd? Okay, 23rd. 23rd. Okay. Let the seniors first do it. All should not wait.
I couldn't see it.
One,
I am a senior behind the senior.
Yes.
He is still a junior.
88, my lord. Suppose you file the response, let them file the response and then we.
CBI.
That on the quashing matters too.
CBI has not filed.
They are supposed to file it.
768.
So Naik is there.
His associate was here, right? Yes, he's there. 88. You have to file response. No, you have to file response. You file response by the next day.
My lord, the exam no problem.
Okay.
Which statement?
Yes. Second May.
Item 65.
Yes, 68. Yes. All the matter I'm going to fix next week or coming week. I'll adjust it. It will be continued. Yes.
Like 68 only. Milots, I'm in 68 only. Milots are short.
Short
Maybe
65. The matter which are there in the list, I'm not able to take it up. I'll adjust that within a week or so.
item.
What? Let him complete first he was mentioned.
Lordship kindly pass now order. Item 80.
Pass an order
means the last time the Lordship gave the last and final chance to the State Council.
I can't take it up. I'll adjust the within a week.
Already 4 5 adjournment.
That may be taken up on 21st.
21st not possible. We'll see.
Item 65.
See, if these kind of dates I will give, then this is bound to happen. I'm not able to take up. Mentioning half an hour, I'll waste, and what will happen?
Item 65 to Lordship, my lord, senior file counter, copy not server Lordship. Let's copy.
I'm also receiving another petition copy. They will tag the matters.
Item counter already filed, copy not sir.
I'm serving a counter copy.
Second item, I am serving the copy of the petition to my lord.
Counter affidavit on behalf of opposite party.
Counter copy I'm supplying.
Copy of the same has been supplied. Lease the matter for peaceful. Yes.
Entry mode.
Entry mode to
items.
Maybe listed after 2 weeks.
I will give you date. Why do you worry? All the matters date will be given short within a week. All dates will be given. Don't worry.
2020 to particularly so Lordship taken make
Okay. The legal counsel for the petitioner submits that she has lost the file and wants to retract the same. Leave the matter in the
Online. Online.
Any day next week, I will take only not more than that.
But they will take, I don't know how much.
No, you will not take more time. That will not take more time. Last again, that.
If you have an understanding, I can't tell anything.
Disposed of by man. At the 130 day, 205 inquiry. And was that order and demanded.
Yes.
Mr. Singh, I have requested Mr. Akhilesh.
Which item?
74. On Tuesday or
74.
On the
Covered item.
1 minute, sir.
Yes. I will not say anything. You file it and get it tagged. Please the matter along with so 60.
Number 2691 of 2022.
Interim or to continue. Yes. Where is that matter? Special notice. Yes. Yes. Yes.
The proceeding between the husband and wife relating to divorce is pending for the land judge family court order. I can to draw my attention to page 31. Page 31,
You are the husband.
I'm the husband. I beg to show to the lordship few orders to show how patently the land trial court.
You come to the straight away. You come to the impugn order by which.
I need to show this order because your lordship will only appreciate the fallacy in the impugned order. Your lordship see the previous order and how his own order he has bypassed.
Show me quickly.
Page 31, your lordship.
Yes.
Order dated 23/6/2023.
Yes. Yes, read it.
My lord.
31.
OP's wife. I say petition with a prayer to direct the petition husband to provide eligible copies of put upon so objection and hearing and evidence. Then your lordship may kindly turn to page 33. Order dated 16/10/2023. This is very vital. Your lordship see the non-trial court judge family court takes note of the petitions that has been filed by the husband petitioner.
Can you? Yes. Please maintain little quiet. I am not able to concentrate.
I am not able to also
concentrate because everybody is talking.
I'm not a regulate for you.
Yes. Yes. Yes.
I hear your lordship see A, B, C, D, E, F, 5 petitions have been filed for different purposes. Now, 2 your lordship will see. Recall respondent number 1 to answer some questions regarding income tax assessment, bank account, so and so, all these things. What a day.
Yes. Yes.
This was for the purpose to show later on the husband discovered.
Who has filed these applications?
Husband.
Yes.
5 petitions. One of the petition is with regard to recalling her to confront the documents relating to her income. Both are well educated and having income. Both are well educated. Now the law and trial court considers that and then passes the order in page 35. Paragraph 3.
Yes.
May I just place it, madam? In view of the above applications, submissions made by both the parties, oral objections, so and so, this court feels that before calling for the above document, the respondent wife appears for proceedings to answer the above points raised in the petition dated 2023, stated in para 1 of this order. So the petition mentioned in para 1B of the order is allowed. All other petitions shall be considered after the examination of the respondent wife. This is very relevant. 5 petitions are kept pending. 1 petition is allowed.
Yes.
Then your lordship sees the next order. the wife doesn't appear. It went on like placing the case for cross-examination of the wife. There is one missing link, that is last page 38, order dated 28/2024. That was placed on 6/9/2024, which was Lordship kind permission, certified copy of the order. 6/9/2024, the wife files a petition under section 25. That was considered. After that, your Lordship sees the order dated 29, that is internal page 13.
Yes.
Again, I filed a petition that if at all she did not turn up, the case went on facing adjournment. 2 petitions are pending. Your Lordship has seen.
Her applications are heard. This is not coming because of that the cross examination that is not.
If a witness is not appearing, then the court can adopt measures to find out the truth. Now, I filed a petition under 151 CPC, the husband filed. That is on 29/2024. That is Annex of 4. Annex of 4, I prayed at page 42.
Yes.
That the documents I have produced may be exhibited, but he is not appearing, court is not ensuring the attendance.
Let us now come to the impugn order. I understood it.
Come to the impugn order.
Yes.
Your Lordship will appreciate what
Yes.
the court has done. That is page 44.
44. Yes.
I will for both sides file Hazira petition dated 29/2024. The court of no objection is filed. On perusal of the record, it is seen that the case is targeted by the Honorable High Court to dispose of the case which stipulated period. The target was long back. Partition finding different kinds of petition to linger this case in different dates. This case is of the year 2016 targeted one.
This observation came because how many applications you moved?
No, those applications the court has said will be considered. Court has never rejected
That's
it.
what it said, yes.
And the application that is allowed is not being implemented.
2016 and targeted one. Yes.
Targeted one. Then the most mistake is now the case is pending for argument. No, case is never pending for argument. It was for the appearance of the wife for cross-examination. The court has allowed it. Now what has the court done? Now court has closed it. Now I have got evidence. I have protested for the court. The court should find out the truth. Now the court has allowed saying that other 5 petitions should be considered. Now you close it, my lord. That is where my grievance is. But the court has made the order directing the wife.
You tell me this order is passed on 4/11/2024. Okay. And the matter was fixed on 13/11/2024 for argument. Thereafter, what happened?
Argument is 4 argument by December 4. December 4, we filed a petition for time, saying that the case is pending. Very honestly, my lord, this petitioner was having some serious ailment in the meanwhile, for which reason the case could not.
No, I am only examining what is the pressing need of the
pressing
hearing.
need is on 4th of December it was there. Now the court has closed it and posted for judgment despite me.
That was done on 4th of November.
No.
Nothing. 2024. Nothing is happening. What is overnight urgency?
Both parties should come for argument. On 4th of December, this 4th of December, the court has closed it, posting it for judgment.
Show me that.
But that I have happened to my record. I have not been able to get the copy. I can never give a irresponsible statement.
Now, where have you said that at least?
No, that I mentioned. That is why the case was listed in the first hour.
Is it is set for pronouncement?
Court has posted for judgment, and I have taken instruction. Mr. Mola Mishra, who is a regular practitioner here, who is local counsel there, he has not given any date also. That is another difficulty why I mentioned today. He has reserved it for judgment, giving no date. And he has verified personally, called me and told me, Mala, I am giving a statement, your lordship may record. And he himself said these petitions need to be considered. I want nothing. I want only to produce the documents for consideration.
Why this matter was not listed?
And secondly, in fact, the case is not getting listed. I mentioned many times, and it was in the list. It could not come out. I cannot give anything more than that listed. So I have to mention, because last 2 days also the Honorable Court did not function. I tried my best, my lord. Less there may be judgment and the instructions I was forced to mention, my lord. This is the problem. And had the court not allowed, I would have no grievance. Court has allowed, court has not ensured that he should come to find out the truth.
Okay. Issue notice to opposite party number 2. Opposite party, only opposite party, yeah? Opposite party, returnable within a week. Give a fixed date, give the date of 21st, least on 2021st. Meanwhile, liberty is granted to the petitioner to move an application for adjournment on the ground that matter is sub judice before the court. And Mr. Mishra and counsel for the petitioner is that the matter is fixed for matter. The argument has already been concluded. Matter is fixed for pronouncement of judgment.
That time of petition for time file class a close petition.
That's what I'm recording. The matter was lastly listed on 4th of December. The argument of both the parties has already been concluded. Matter is set for final disposal. In view thereof, therefore, the petitioner is granted liberty to move an application before the trial court for adjournment. Since the matter is listed for final disposal before this court on 21st of April. Okay, 21st.
And adjournment maybe.
That's what I'm saying. You move an application for adjournment, the trial court will adjourn it till 21st. Till 21st. 21st, it will go to the regular bench. I can accommodate to that extent because it's not the regular court. So to that extent, I done it.
And the only problem was there is no date also. There is a date of pronouncement of judgment, things should have been different.
No, it's a final disposal.
Argument
is concluded and is set for
argument भी कहीं करना है. Time petition rejected, case closed, posted for judgment. Nobody, he is not appearing.
Can you show me that case closed? Where does it say?
Case is posted for judgment. You will record my statement. I am an officer of court. I have never given in my life and my responsibility.
That's what I have recorded. Your statement I am recording. I'm saying that argument is concluded. Both the parties are.
Time petition rejected, case closed. Argument ke karna hai. Mr. Mishra says he has not argued.
Put up on 13/1/11/2024 for arguments.
Yeah. Sena petition for time for 4 December को रहेला sena petition for time दियाला on the ground that WPC number so and so has been filed for the Hon'Ble High Court. The case has not been listed. The court says time petition rejected. Exact language I cannot produce. Case closed. Pronounced.
Mr. Mishra, Mr. Mishra, and counsel, senior counsel submits that although the matter was by impugn order dated 4/11/2024, although the matter was adjourned for 13/11/2024 for arguments, but the parties are not finally heard. Rather, the matter was lastly listed on 4th of December. Thereafter, the matter is set for pronouncement of judgment. In that view of the matter, the petitioner is granted liberty to move application for adjournment. If the matter is adjournment, move an application before the trial court not to pronounce the judgment. Not to pronounce the judgment because the present matter is listed before the regular bench on 21st of April. 21st of April.
My requisite shall file on 15th.
You file it. File the requisite.
Last day.
Yes.
11th. Tomorrow is a holiday.
Requisite to file within the first by Tuesday. Okay.
So grateful, my.
Item 76 interim order may be extended. Item 76.
I have not taken up your matter.
Oh.
Oh.
So